I'll just do a quick run. Thank you for that. And this is, you're welcome to this again. This is brought to you by Center for Human Rights under the Expression, Information and Digital Rights Unit. Together with the Healing Way, who is the manager of this unit, and other colleagues, Sit and I and the rest, work tirelessly to have this symposium. We want to thank you, and we're going to go straight into it. But just in less than a minute, I want to give you a program outlook on how day 2 is going to look like. We had a wonderful day 1 yesterday. And day 1, we looked at major 2 themes. And today we are going to look at 2 themes, and we hope that by 1 p.m. South African time, we should be able to finish this symposium. So today we are going to look at 2 themes, one on cross-border and regional dynamics. We shall have Ian Makambu, Dr. Mugambi, and Tapiwa talk about issues. And then after death, what happens? I think that's one of the biggest questions we had yesterday in the discussion. So we'll go data protection. And then we will have the issue of geopolitics, sovereignty, and surveillance. China and cybersecurity. I know most of us have talked about China and cybersecurity. What does that mean? And also talk about digital sovereignty in Africa, Chinese safe cities in Africa, AI, integrated payment systems and data protection. And these will be very interesting papers. So I ask you to participate, ask questions, and also let us enjoy this discussion. And we hope that 1 p.m. South African time, we should be able to close this session for today. So thank you so much. And now I want to go and ask, and I want to find out if I see Dr. Mugambi is online. I don't know if Ian is online. I also know Tapiwa is online. So right now I'm going to ask Ian to take it on from here. We all have about 10 minutes to present the papers, and colleagues, after every paper, we'll have a discussion so that we don't lose track. So thank you very much. Over to you, Ian. I'll stop sharing my side. Let me just check and be sure that Ian is online.
Thank you.
There you go.
On my end.
Yes, you can proceed. I see you're muted. Okay, you're sharing. Very good.
Good morning, colleagues. Thank you very much for the opportunity to join you on the second day of the symposium. I shall be presenting on my paper, which focus is on harmonizing of cross-border data flows in East Africa. We are drawing lessons from ECOWAS model law on digital trade, and we are also drawing lessons from global practices. As you've heard, my name is Ian Makambu Mongare. I'm the acting head of data protection services at Southend Tech Limited, which is a private practice consulting firm that assists individuals and organizations achieve data protection compliance. We do understand that data flows cross borders, and it is the cornerstone of digital economy, particularly for the East African community, where they have a projected growth of just about 6.8% annually. That's the CAGR. A significant part of this growth is dependent on digital integration. But a major challenge is that there is a lot of fragmented enforcement and, again, limited institutional trust. But what we're trying to say is that trust and cost effectiveness that ensures there is seamless and secure data transfer, it remains entirely critical to boost e-commerce as one of the areas where the EAC's projected growth is expected to come from. In this paper, I'm seeking to examine the legal and institutional impediments to cross-border data transfer. I'm also seeking to compare EAC laws with ECOWAS model law, and then propose a harmonized framework that will ensure that we get safe and trusted data mobility. I adopt combination of both doctrinal and non-doctrinal comparative analysis by first of all comparing the different laws present within the East African community, and then looking at the ECOWAS region and the laws that are present there, which we could borrow from. Of course, the comparative analysis extends to even global laws. With respect to non-doctrinal, the comparative analysis in this case takes an approach of a review of the socioeconomic context that results now from the laws that are present, the laws that have been passed, and how do these laws now influence businesses, organizations, and individuals in general to adapt to the laws that have been made. It is proper for us to gain a regional context on this regard, particularly in East Africa. Whenever we are talking of cross-border data flows, we are working on the backdrop that the East African region is experiencing a rising internet penetration, just about 44% between 2023 to 56% in 2024. In terms of mobile money market, where a lot of data equally flows, the East African community is doing almost $84 million in transactions. The e-commerce in itself is expected to hit about 9.82 billion by 2030. But then again, EAC records the slowest pace of digitalization. So my paper seeks to query whether the restrictions in cross-border data transfer, the fragmented laws, are part of what is causing the slowest pace of digitalization as yet. Well, of course, this paper shall consider that there are other factors, and I shall take into keen consideration some of these factors. But emphasis is placed on the barriers to data mobility, where, first of all, the paper takes note that the fragmented data protection laws is indeed a big challenge. Further, in addition to these data protection laws, there's strict adequacy requirements, which then, of course, create the bottlenecks in terms of compliance for organizations. Because the question is the other country wherein we intend to transfer our data, does the other country have strict, adequate protection measures, which some countries may require for it to be essentially equivalent, and some may require for it to be, similar and almost the same to the host country. So weak institutional capacity of data protection authorities in the region is also a factor, although we have seen complete change in the past 2 to 3 years in terms of the DPAs. The authorities have shown a strong hand, particularly in terms of offering determinations and making determinations, even to the extent of MNCs, which are very much implicated in cross-border data transfer. So while in essence there is some part of the institutional capacity improving, and as we shall see later in the presentation, weak institutional capacity remains a significant challenge with respect to data mobility. I also find that gender gap and language exclusion is again a significant barrier to data mobility. And with that, emphasis is placed on the fact that inclusivity approaches should also be factored in when we're developing harmonized laws, because this is the only way that we shall ascertain that there is increased trust if the harmonized laws shall come in to deal with the digital inequality that currently exists. I base the arguments of my paper on the two theoretical models, as you can see. First of all, I consider the adequacy model. Of course, this is destination-based trust as practiced within the GDPR. It is a requirement for the data controllers, the data handlers within the local country to affirm and satisfy themselves, and to some extent satisfy the Data Protection Authority that the destination can be trusted in terms of adequate measures of data protection. Then there is an accountability method, an accountability model, particularly used in the Asian region, where it is exporters' responsibility to ensure that the data protection obligations as mandated by the Act and relevant regulations are complied to. This is regardless of the destination, of course. This means that it is the data handler's responsibility to ensure that contractual agreements have standard contractual clauses, that they're binding corporate rules, between organizations that are doing the data transfers, and further that they go beyond to ensure that the organizations to whom they're transferring the data have taken serious measures to ensure data protection shall be combined. So the current ESC reality would mean that, of course, given that there are fragmented data protection requirements, particularly on cross-border data transfer, the most appropriate method will be a hybrid model that combines both the adequacy aspect, combines an accountability aspect, and then equally brings in a third aspect called the mutual recognition. Because, of course, whenever we're talking about the trust of adequacy and accountability, there needs to be a mutual recognition between the ESA countries of each other's capability and capacities to ensure cross-border data transfer is done within the ambits of the law. My argument is that privacy within cross-border data flows cannot be sustained by destination-based assessments alone, and hence my proposal, or rather the proposal of the paper, taking the approach that we need to combine all these three approaches. The paper gives a legal landscape, and from what you can see on the screen is that significantly, and I think present within the data protection general regulations of Kenya, that one of the considerations that data handlers should have, particularly when they are considering transferring data across the country, is whether the host country or the destination country has ratified the Malabo Protocol. But as you can see, the Malabo Convention, but as you can see, it is only Rwanda out of the 6 countries with data protection laws in the East Africa community that has ratified the convention. Kenya had discussions on the accession of the convention recently, but clearly all the other nations, all the other states are yet to ratify the convention. Well, the convention gives a clear and I would say easy, quote unquote, approach to cross-border data flows, but clearly the lack of a concerted effort towards achieving a harmonization of laws is indeed a great challenge. In terms of the models that each of the countries is using, we can see that Kenya combines both the adequacy and the accountability approach. Uganda focuses mostly on the adequacy, with emphasis on that the destination country must have essentially equivalent protection measures. Now, if we tend to think about the terminology of essentially equivalent, well, of course, it leaves a wide range where different definitions can pop in, but this is now where the mutual recognition argument that comes in the paper lies, because it will demand that even countries that are focusing mostly on adequacy, they'll need to mutually recognize that essentially equivalent may be limited in terms of its considerations. But then again, it is something that is occurring. So Tanzania combines, again, adequacy and accountability. Rwanda focuses most on accountability, emphasizing that organizations and data handlers should take the responsibility themselves. Somalia combines itself, and adequacy is considered as the model that best works for DRC. So you can see the fragmentation that I had earlier on spoken about coming out clearly in this perspective. In terms of institutional approaches, we've had the Kenya ODPC being very apt in terms of providing guidelines, providing determinations, which continue to shape the conversation around data protection laws and mandates for both organizations and individuals alike. The Ugandan PDPO has equally been very apt with its, most recent decision against Google, emphasizing its let's say mandate in terms of drawing and charting the path that data protection should flow. The Tanzania PDPC has equally been very great, in actively reviewing transfer applications, and those from Tanzania who are doing cross-border data transfer can affirm that there is a requirement that whenever you're doing the cross-border data transfers, you should actively apply so that you get an approval for the transfer to be done. In terms of Rwanda, the NCSA has enforced the accountability approach, particularly in providing model laws, model contractual clauses. But again, there is limited enforcement records. So the essence of the institutional consideration is to emphasize on the aspect of institutional trust, because at the very end, when we are proposing that we should have an harmonized law, we are also proposing that there should be a trust within the data subjects, within the organizations and data handlers, that they can seek redress, or rather that the data protection authorities within the respective countries can push and advance the legislations and the mandates and the obligations as contained within the harmonized framework. So essentially, it is imperative for us to understand that achieving that integration is embedded, rather it is appended to us developing institutional trust. In terms of regional initiatives that could, promote the possibility of a harmonized framework, there is the East Africa Regional Digital Integration Program or project that is currently undergoing, and which seeks to digitally integrate the East Africa region. So the current phase is in Somalia and the Horn of Africa region, where they are focusing mostly on digital expansion to increase internet penetration and to promote regional integration, particularly within that region. Such a program and such an initiative also emphasizes the need to ensure that there is secure data exchange across the different countries. And what better way, to promote this program than by having a harmonized framework that shall guide, the flow of data, especially for businesses that are focusing on e-commerce. There is the One Network area, which has been there for a minute, and it has recent developments from the owner have been the elimination of roaming tariffs with an aim of boosting e-commerce. Whenever we are talking about boosting e-commerce, again, we should also remember the amount of data that flows whenever we are talking about e-commerce, and the need to ensure that these data flows, again, are protected. There is also the Mission 300, which is a World Bank project that seeks to ensure that over 300 million people are connected to electricity within the East and Central Africa region. Well, of course, with electricity access comes digital growth, and with digital growth comes the flow of data and the need for us to ensure that this flow of data, again, shall be protected in any case. The research from ECOWAS emphasizes that the ECOWAS model laws on digital trust and again on electronic transactions brings about something called the e-signatures, and understanding that e-signatures again can be recognized by law, and bringing about the aspect of interoperability of systems such that what systems are used in this particular country then can flow into another country and be considered as interoperable, particularly in terms of Electronic Transaction Act, despite, of course, the differences in structural and functional objectives. The laws also emphasize that countries should form independent DPAs, which is trust-based enforcement, where it is not a responsibility of the country, because there are some countries that, of course, do not have DPAs, and the issue of independence, of course, is very, very, crafty, particularly for the African context. But one key thing and one key lesson that the paper seeks to, gain from the ECOWAS model law is the reciprocity-based adequacy within ECOWAS, that countries can recognize each other and recognize that adequacy within the other country has been achieved. Therefore, data can flow easily between our countries on this basis. So again, we could gain from the certification process and ensuring that organizations can be certified as having complied, and of course have the certification to be renewed. So if we combine now adequacy, we combine accountability, and then we combine certification, we are coming up with a system that is very trust-based and a system that is very fortified to ensure that at the end of the day, we have elaborate structures and formats, frameworks that will govern cross-border data transfer, data flows in a harmonized format. Then comes my proposal, rather the proposal of the paper, on what this framework should take. First of all, I am proposing a mutual recognition of essentially equivalent protections. That if Tanzania has already fulfilled, these particular aspects of the essentially equivalent protections, do they have a Data Protection Act? Yes. Do they have a somewhat independent DPA? Yes. Are there, standard contractual clauses? No. Are there determinations that have already been made in particular to this issue? Yes. If they fulfill these conditions, then there is a mutual recognition that Tanzania and Kenya can enter into an agreement, and an adequacy decision is made to this effect. Then comes the layer 2, where in addition to the adequacy, in layer 1, in layer 2, we come up now with standard EAC clauses, which should also take consideration that they do not have to be heavyweight for the enterprises, because SMEs are also participating in cross-border data flows. And given that compliance has become very expensive, SMEs is, or rather will be, a data breach risk if the standard EAC clauses that are proposed under layer 2 are not considered to be lightweight, of course, to meet their operational thresholds. Then comes layer 3, and in which we are proposing, rather the paper is proposing, that we have a privacy seal, where it should work as a certification of sorts. In addition to the country being declared as adequate and data flows can occur, in addition to organizations now being accountable and data handlers being accountable to ensure that contractual risks and exposure is limited, then we can have certifications for organizations with an option of even extending it to make it also GDPR interoperable. And the certification shall seem, or rather the entire framework shall seek to ensure that we have seamless cross-border data transfers without the repetitive approvals that continue to impede business and efficiency within business particularly. So that is the approach that my paper is taking in terms of, proposing an ESC model framework that should be adopted within the ESC to ensure that we boost trade, we boost, digital growth, and we also ensure that even while doing this, we are proposing to do it within protections of, or rather while protecting the data of our data subjects. Thank you very much for listening.
All right. Thank you, Ian, for that interesting conversation about cross-border conversations about data and how we can both, countries in East Africa can do that. It's saddening that only Rwanda has ratified the Malabo Convention. I hope that the other countries can do the same. So if there are questions and comments for Ian, please just shoot your hand up so that I pick on you, or you can go straight on. But Ian, I think mine would be on the, given that I come from East Africa, I have some interest about that. The mutual recognition agreements in Africa, what is their efficacy? This is something you can reflect on in terms of, because I think there is one which has been pending for legal practice across the countries, and there have been, I think, reluctances on the same. So especially to deal with people wanting to protect their markets, but at the same time, the legal framework, how do we ensure that this happens? You have Rwanda and other countries that are not common law. They are probably just migrating. How does that work around mutual recognition agreements? So I think my point is that that's an interesting one, but to just look at how the others probably are working when or not working, and how that will also do for the data protection authorities. I think that would be good to just dive into, just give a kind of juxtaposition on the ones that are working and how best that would work for the data protection, for the data protection in these African countries. Thank you very much. Anyone has a question, a comment? Please do it now so that we can proceed. Ilingwe, any comment for Ian?
Maybe you can respond to yours first, and then I can come back with my comment.
All right, thank you. Ian? Thank you very much, Michael, for that. In terms of the mutually recognition agreements, there is a potential for that, but of course you raise very critical considerations that I think I'll have to go back into in terms of when preparing the final submission. But in terms of what is working and how we can provide further guidance in so far, there have been, the ESC e-commerce strategy that can provide us with a basis to start. And this strategy also considers that each of the different countries have their own, e-commerce strategy. But when we come to the ESC, we are moving forward, driven by need for integration and driven by concern for ensuring that the data that is contained, or rather that flows within the different countries is operating. Particularly on the issue of the protection of markets, I think the approach that this should take is that in addition to ensuring that, first of all, it is coming from the basis that the data transfers are already happening. Companies have, groups of banks, let's say, the KCB is operating in Kenya and Rwanda. Equity has branches in Uganda and Rwanda as well. And, these are cross-border data transfer is already happening. And it is fundamental to argue for the fact that if there are harmonized data, there is a harmonized data framework, then it becomes easier for these organizations that are currently having to, conduct the repetitive exercise of pursuing adequacy decisions and pursuing approval decisions. So if we can ease this part and ensure that, argue for the fact that it will open up, the current and ongoing business practices towards easier approaches, then perhaps there is an argument to be made there. But well, of course, thank you for your guidance in terms of this particular direction. And I particularly want to also thank you for the guidance on whether the very different, legal should I say, approaches Rwanda operating from not a common law perspective, and how such will really impact the possibilities of us having a harmonized framework. Thank you for your guidance in that regard.
Thanks, Michael. Let me just a few issues. I think one of my issues is related to what has been raised. So in the paper, Ian, you call for a hybrid or pragmatic approach combining adequacy and accountability, if I got that right. I think somebody who's reviewing your paper would be interested also in getting a sense of the implementation or criteria for how mutual recognition or interoperability would function, especially when you're looking across divergent national legal systems. So how does the proposed model, for instance, navigate the conflicts between the local adequacy tests and regional recognition? That would be my first question. And then also there is an issue of institutional trust, which seems to be central in your argument. But I think it will be great to clarify how institutional trust is operationalized. Is is it in relation to enforcement actions? Is it in relation to cross-border cooperation agreements? Questions like that, and whether the assessment, what does the assessment, where is it drawn from? What is the data in which you are basing this this concept on? And also, how does institutional trust correlate with cross-border data flows, efficiency and compliance behavior? So yes, that's my second issue on institutional trust. And then also I'm interested in getting your thinking around your position on data localization and digital sovereignty vis-a-vis regional harmonization. So I think your paper critiques localization as, do you use blunt instrument? But I wonder whether you then go on to address what can be referred to as state interest and sovereignty, legitimate state interests and sovereignty issues related to cybersecurity. Yeah, so do you propose an East African framework that would allow conditional localization for public interest or national security? And essentially, how does it reconcile, sovereignty concerns with economic integration? And is there like sort of a nuanced typology of good versus bad localization policies if you're looking at probably the East African context? Yeah, let me stop here for now.
Yeah, thank you, Ilingwe. Ian?
Thank you very much, Lingi, for those very, very interesting point outs and critiques of the same. Maybe to respond, although I wish to say that I may need to particularly go further and explore them in terms of how they now would mesh into my proposed paper. Particularly, the very first question on how does the proposed model seek to, navigate the fragmented legal frameworks that currently exist. I would wish to now marry that with the second question and some part of the second question on how the institutional trust come to play in terms of ensuring that now, the framework shall relate to or rather can relate to the trust. Recently, there was a discussion on whether the ODPC in Kenya, which is the commission that is mandated to act on data protection laws in Kenya, the question was on whether it had made an adequacy decision as yet, as mandated by the Data Protection Act, which demands that the institution should go ahead and make a determination of a list of countries that the ODPC considers as having adequate protections. And since the Data Protection Act was enacted in Kenya, there has not been any determination that has been made. That is 6 years later. So some of these aspects on whether you can trust the institution to go ahead, and make the determinations, despite now the fact that there are other organizations, or rather, despite the fact that organizations have not sought for the adequacy decisions to be made, then brings into the question of institutional trust. Now, when we say we shall be adopting a three-layered framework that essentially bases on an adequacy approach, then we need to be affirmed as organizations, as data handlers, as data subjects, that these institutions can actually, go ahead and provide and make the adequacy decisions as at yet. In terms of whether the trust comes in terms of the enforcement or whether it comes in terms of the mutually recognizable agreement, then my argument again, I think would be on both and will be on all. In terms of institutional trust, I would also maybe include another aspect of the political influence that may come, particularly for the organizations, for the authorities, which are dependent on the exchequer and the political movers for fundings. So these are critical questions that may influence the public's confidence in institutional trust. And again, to mesh the very first and the second question and bring about the aspect of, suppose the DPA in Kenya has made a determination, which a business in Uganda particularly feels that is not okay to their business, or it might impact their business significantly. Then further, the DPA, or rather the PDPC in Tanzania then comes again and makes a determination, which a business, an enterprise in Kenya particularly feels that this decision has not been made with the interest of the East Africa harmonized framework in general. So some of these are issues that particularly, or rather will particularly be very keen to look into, but I think they will better come into perspective when the harmonized framework is already in place and we are dealing with actual issues of whether the trust is there or not. But in so far, I think the trust has been pegged on the fact that the determinations that have been made by the commissions so far, the authorities so far, have shown a strong hand and have shown a strong influence, particularly
Thank you, Ian. Michael, if you can allow me to just ask also another set of questions as well that I believe can help us to shape the paper. Yesterday, I don't know if you attended yesterday, but I think there were also issues around the African Continental Free Trade area, and the digital trade protocol. We also had a presentation around AU data policy framework. And if you look at the Continental Free Trade Area agreements and all that, they outline cross-border data principles. So now, with regards your paper, the model that you are proposing, does it seek to complement or the African Continental Free Trade Area, for instance? And the way you look at it, how does it align, or how is it different from the AU existing frameworks? And then also, when you look at you mentioned the ECOWAS in your paper, and for me at the moment, the way it's framed right now, it's a bit more descriptive. I wish you can be a bit more explicit in terms of how what is the relevance of ECOWAS in your paper, and especially when you now get to proposing the model that you are proposing. Are you, for instance, looking at certain institutional designs from the ECOWAS that you think can be adapted in the East African context? Something like that. What are there particular provisions in the framework that can, that you are drawing inspiration from? So I think maybe you should be more explicit in terms of that, use of the of the ECOWAS and how it informs the harmonization proposal that you are bringing. I think also I had forgotten, I had a question around the seal and the privacy seal and standard conceptual clauses. What was my thinking, my question? I think around how that would align, for instance, with global trade agreements, ensuring that, you know, the East African community remains competitive in global data markets, and also the issues around oversight, you know, enforcement, or whether, you know, when you talk about, you know, governance of certification schemes, is it going to be voluntary? Are you thinking of something mandatory? Sorry for loading you with questions, but I think I recognize some gaps which need to be clarified.
Thank you.
Michael, yeah.
Ian?
Yes, thank you for those illuminating questions. Particularly to begin with the AFCTFA and you know the AU Digital Protocol and the data policy framework. My paper rests you know at the center of all these, which seek to ensure that you know the trade area within Africa is you know is free while also respecting you know the different you know regional economic zones interest and the regional state no the individual state interest. Particularly the data policy framework emphasizes on the need for you know the growth in the digital what the digital economy, which you know the data policy framework emphasizes, is an avenue that will seek to you know drive the African youth ahead, particularly considering the issues of unemployment and such related factors. So I do believe that if I can be able to mesh, you know, the three specific and African region-wide, let me say framework, then it can be a way to, you know, strengthen it, strengthen the paper particularly from that front, and give it basis towards pursuing a harmonized framework. With respect to the lessons that I'm drawing from ECOWAS, yes, I do agree that from the approach that I've currently taken, emphasis has been placed particularly on the design. There is indeed a lack of the particular provisions that I could perhaps draw from both the Personal Data Protection Act that applies for ECOWAS and the Supplementary Act on Electronic Transactions that equally applies on the same. But I do believe that the illuminating questions that you've asked will indeed manage to cover in that regard. But maybe to propose on the governance mechanisms, I think my paper pays reference to, or rather, my paper pays reference to the adoption of a possible authority, overall authority, that shall work in the same way the ESCJ has worked in the recent past, to provide determinations that can be considered across the ESCJ. Well, of course, this is not blind to the fact that some of the determinations by the ESCJ have faced significant challenges in terms of enforcement and execution of the determinations, and this will be a possible factor for the proposed, you know, overall authority. But it is my belief that perhaps beginning with the institutional trust that I seek to emphasize significantly again in the paper, I do believe that it should be a basis for which then we can approach a possible regional enforcement authority for the same. But again, I would wish to thank Lengiwe for the illuminating questions on the same. I do believe I've also recognized the gaps particularly on whether the certification should be voluntary and mandatory. And again, considering the fact that there has been some serious legitimate state interests that have been in so far limited the possibility of even acceding or rather ratifying the Malabo Convention in so far. So I would say thank you, Lengiwe, for that.
All right, thank you very much, Ian. That we look forward to seeing the full paper to that. All right, so thank you very much. We will now move to Dr. Mugambi. And Dr. Mugambi is going to look at the posthumous privacy in Kenya. We had a very interesting discussion yesterday on whether after you die, you still have a right to privacy. So let us hear from Dr. Mugambi on the angle of Kenya. Dr. Mugambi, over to you.
Thank you, Michael. So my paper is based on that question. When somebody passes on in Kenya, then what happens to your data? Because ideally, especially with the expansion of technologies, we find that data lies around. I mean, just to give an example, if you go to our loved ones' social media pages, you'll find that their photos, the information is still there. Some may run YouTube pages or pages that basically can be monetized. So the question that arises is whether privacy survives beyond the grave, and if it does, what should the law say? So in Kenya, especially, so when you look at in Kenya, for example, personal causes such as defamation, breach of confidence, they usually die with the person. So you find that when you look at, for example, we have the Law Reform Act, which provides that if someone dies, these courses of action, I mean, like I said, issues to deal with defamation, seduction, inducement of a spouse, etc. Those really, as you see, these are some colonial provisions, but they say those ones will extinguish on death, and they say that damages are actually restricted. And what the Law Reform Act does is it sets procedural limitation on claims after death. So after death, what it means is that if you are making these claims, you have to go to court through the Law of Succession Act. I think many countries, which are Commonwealth countries, have either you call them probated administration laws or Law of Succession Act, where you go to court. And then you have a grant of representation, where representatives of the deceased estate can now take over these proceedings. But it's also important to note that the Law Reform Act does not mention privacy or data protection rights or access to information as some of the courses of action that may be taken over by the representatives of the deceased. Then also the question arises, what about access to information relating to a deceased person? Is it subject to constitutional and statutory limitations? For example, Article 35 of the Kenyan Constitution provides for the right to access of information. But courts have clarified this. So one of the decisions that actually led me to think deeply about posthumous right to privacy, there's a decision. It's actually a very short decision, but it's quite impactful. It's Mwaneki versus the Attorney General at the Kenyan High Court, where the court said that one may not demand for obtain information about a deceased person's account or estate unless they have authority through a grant of probate or letters of administration. So essentially, the court was saying if you don't have legal standing, then disclosure of a deceased information will be an invasion of the privacy of the deceased estate. And verbatim, the court says without requisite representation, any disclosure to the petitioner will be tantamount to impeding the due process of the law and will amount to unwarranted invasion of the privacy of the deceased estate. So when I read this decision, last year, the question was that, so what does this mean? It says it essentially means that if you want to access somebody's records, whether it's bank account, property records, health records, etc., then that must be done through some due process. You have to be a duly appointed representative. And secondly, the court seems to recognize that there's a right to privacy of the deceased estate. So the question is, does this also mean that the deceased has a right to privacy? So when you look at the Law Reform Act that says defamation is distinguished upon death, and then here comes the issue of the right to privacy. So now we have the Law Reform Act, the Law of Succession, and Mwaniki versus the Attorney General, and we also have civil procedure rules that provides what happens to a suit when a person dies. So one of the questions is what happens to a privacy suit, a data protection complaint when somebody dies? So when you look at Order 24 of our civil procedure rules, usually says that if a plaintiff dies, then the estate may take over representation. But then, as I said, the question again arises, which I state in the paper: what about to privacy and personal and data protection claim once a person dies? So, in my view, if you follow the Mwaneki versus Attorney General decision, we can arguably state that legal representation, of course, it's paramount. Then I make an argument that when you look at Section 27C of our Data Protection Act, it says that a right conferred on a data subject may be exercised in any other case by a person duly authorized by the data subject. So I take a long shot and say, you know what? If we read Moneki versus Attorney General and you look at Section 27C of the Data Protection Act, it actually means if you're saying that the data subject rights can be exercised by the duly authorized representative, then we can actually say that the data protection, these rights survive the death of the data subject. That if I appoint somebody to exercise my data subject rights when I die, then we can essentially say that my data protection rights under the Data Protection Act survive my demise. But then the question is that does the Data Protection Act, the Kenyan Data Protection Act, acknowledge or does it recognize the death of a dead person as being a data subject? In as much as I've said, I've shot in the dark and I've said Section 27C, Mwaneki versus Attorney General, point to the fact that somebody can say, upon my demise, I'll be represented by so and so to exercise my data subject rights. So when you look at the law, our Data Protection Act, when it talks about a data subject, it talks about an identified or an identifiable person who is subject to personal data. So the question is, natural person. Can we say that a natural person is also somebody who is dead? So in traditional legal doctrine, natural person is a living person who has a legal personality. So essentially, upon death, that legal personality will cease to exist. So we can argue that, so what we say is that natural person does not extend beyond death unless the law says it. But then our Data Protection Act talks about an identified and identifiable natural person. Anyway, let's look at in my paper, I made several contrasts. I made Rwanda, Ethiopia, Senegal, Ivory Coast, and Tunisia that says something about this, about the data protection rights of somebody who's deceased. So Article 3, when you read Article 3 and Article 25 of the Rwandan law relating to personal data protection, it says that, of course, one, that the data of a data subject is not subject to succession. So you cannot inherit somebody's data. Secondly, but interesting, I've not found any decision relating to this in Rwanda, but I'm sure it will be subject to litigation at some point. But it also says that where a data subject has left a will and the data subject provides that his or their heir will provide their heir with full or restricted rights relating to processing of their personal data, then that data will only be used according to that direction. If you look at Article 23 of the Ethiopian Personal Data Protection Proclamation, it provides that personal data of a deceased, that their rights remain for 10 years after their passing. So Ethiopia provides a period within which an heir is entitled to exercise the rights of the deceased person within that time. So it sort of strikes a balance. It doesn't extinguish completely, but says after 10 years, you have 10 years to exercise these rights through a succession process where there is an heir. The Senegalese law concerning personal data protection provides that for access of medical records, that can only be done by close members of persons who have been identified within a legal process. Article 32 of the Ivory Coast Law on Personal Data Protection also provides that for rights of a deceased person, that the data controller, the data handler, is obligated to make this data available to the successors of the deceased, and it's also to ensure that accurate records of the deceased are kept. Article 30 of Tunisia's organic law on data protection also talks about limitation on death, and it, of course, it prohibits use of personal data for commercial purposes. But it says in the case of incapacity or death, then the legal representatives may take over the rights of the data subject. So when we look at Tunisia, Ivory Coast, Ethiopia, Rwanda, we see that unlike the data protection Act of Kenya, which is silent on this, these countries seem to indicate that there's some sort of regional trend, or there's some sort of tradition that is being formed here that bridges death and information self determination. But then we also go to the extreme case where there's very clear indication that data protection does not apply to somebody who's deceased. And this is POPIA, the Protection of Personal Information Act. Of South Africa, which defines that personal information is information that relates to an identifiable living natural person. So it's very explicit. Actually, in my paper, I underline the word living. So it's very clear. You have to be living for you for the rights and the POPIA to operate. Then if we go look at the EU GDPR, it also clarifies, when you look at recital 27, it clarifies that the regulation does not apply to deceased persons, but also confirm that European member states can decide how they are going to deal with personal data of deceased person. And interestingly, before the GDPR in France, they had a chapter that was very clear on how personal data will be handled after death. But for some reason, they just extinguished it. I think it's because of recital 27 of the GDPR, such that it doesn't apply. But what chapter 5 of the French law said before the GDPR was enacted is that when alive, somebody could give direction as to how their personal data is to be handled once they pass on. But then the question is that there are these countries, there's the EU GDPR, there's POPIA, there's the Kenyan Data Protection Act. But what is the reality in Kenya? We say, what is the reality on the ground? So when you look at the evolving concept of posthumous privacy, is that in our lifetime, in your lifetime, my lifetime, we put a lot of information in digital form. Our social media platforms, our emails, phone numbers, messages, digital files, all this we create. And when you look at the digital infrastructure, even after we've stopped posting, it still continues to crunch that information and that data. And for example, as I said, your social media accounts have your personal data. Some have your biometric data. You have bank accounts that data is stored in digital forms. You have health records that are stored in digital form. So the fact is that upon someone's death, whether it's in hard copy or soft copy or in digital form, these records still survive. And these records may be used for different for different purposes. So this debate has been going on in that, yes, I mean, like I said, we have loved ones who've passed on, but when you look, when you go look at their social media pages, there are people interacting with those social media pages. So the question also arises: do we say that if somebody passes on, that their data can be used, for example, for generative AI? Can we replicate? I mean, we have software that if you provide photos of our deceased loved ones, they can animate them, and you can find that they are saying something. Somebody who passed on, then it's animated, and they're speaking something. But then I go back and say we must pay attention to the realities of how digitization and the technology is moving. And I go back to an article that a lot of privacy scholars use, the article by Warren and Brandeis, when they were conceptualizing the concept of privacy, where they said that there was this new technology called photographs and newspapers that was infringing on the privacy of individuals. And they said this, with this new technology, there are some harms that come up with this technology. Then we must design the law to pay attention to this new technology that is coming. So you see, my argument is that we have new technology, and this new technology has effect on us, whether we are alive or once we are deceased. So if over the years we have been formulating or reconceptualizing the right to privacy for living persons, then we need to think about now the right to privacy or data protection rights for persons who are deceased, because in posthumous context, data, images, digital legacy survive the data subject. So the question is that should they be free for all? And my argument is like, no, not really. But also, I refer to, when you look at social media platform, for example, if you go to Facebook, you can identify what we call a legacy contact. You can designate somebody who and a legacy contact is somebody you identify when you are alive, and then you can have that person do certain things to your account, either delete it or memorialize it. But of course, there are limitations. This person doesn't have access, for example, to direct messaging, but they'll be given a right to do something to that account. On LinkedIn, when somebody using LinkedIn passes on, the account may be memorialized, or duly authorized representatives of the estate may request full account deletion. But as you say, LinkedIn is very clear, it must be an authorized legal representative. For Apple users, you may designate a legacy contact who will have access to certain information within the Apple account. But Apple indicates you must provide a death certificate and authorization, legal authorization, which means the probate and administration process must have taken place. But for Apple, you can't access stored passwords, payment information, subscription, purchases, etc. So as we see in our lifetime, one's lifetime, we accumulate a lot of these digital assets, a lot of information, some of it that has financial value. Like, for example, YouTube channel, domains name, bank accounts, e-commerce store, intellectual property, ebooks, music, design files, etc. So the question is, if somebody has, and all these digital, what do we call these digital assets, contain a lot of personal data, and they have economic value. And if they have economic value, it means that they could be subject to succession proceedings. The interesting bit in my research, I've not found any case whereby digital assets have been subject to probate or succession proceedings in Kenya. But then, so what means is that if these assets are not properly handled, then they could be subject to hacking, fraud, and unauthorized exploitation. And the heirs of the deceased may not profit from these assets that their loved ones left behind. So also, apart from the monetization part, the privacy concerns also arise because the exploitation of these digital assets exposed personal data. So it raises very complex issues about digital legacies, how social accounts are managed after death, and how they should be controlled. Then I also raised the issue of posthumous harms. Can there be posthumous? Can somebody be harmed? I mean, you can't defame. For example, people essentially within the Kenyan law is that somebody who's deceased cannot be defamed. But can somebody's privacy be infringed once they pass on? And one of the challenges is that when somebody is deceased, they can't control their personal data. But then the lack of control of personal data when once passes on is the issues of deepfakes. I mean, recently, I think you've seen online where you've seen the Queen, the late Queen of England, rapping or singing. You find Martin Luther King dancing or that kind of thing. We find online Robert Mugabe, the late Robert Mugabe, saying something. So the fact is that the digital recreation usually sets some sort of realistic images or clips. And for people who can't speak for themselves, then their reputation and memory is harmed. And because my argument is that somebody's legacy is is really important, and that if we are producing hyper-realistic reproductions of people's voices, faces, and likeness, which is personal data, then we are raising issues of consent and identity usurpation. I give an example of a documentary that was done relating to Anthony Bourdain, and it was done by AI, and of course the family was really upset because they're saying he never ever said this. So the issues of consent, transparency, and profiting from the data of the dead. And some of them, they create very disturbing and realistic images using this kind of technology. So unlike traditional violations, like where you can go and disrupt a funeral, this one creates a new form of psychologically or damaging effect, whereby even the people who are living, I mean, like for example, I've given an example of platforms like My Heritage, Nostalgia, or Deep Story, where now it can even bring these ethical concerns, because the question, did this person say this, or you put this person in a position that they never were when they were alive. So it brings the issue, these platforms that are exploiting the data of these dead persons, the issues of trust, the issues of regulation, the issues of deep fakes, the issue of hyper-realistic reproduction. They risk the identity, they risk the memorialization of this person. It becomes issue of financial exploitation of the deceased, because they're not in a position to either consent, they're not in a position to consent. And also, there's the issue of protection of the living. The living, for example, is that they have a right to inherit from the estate of the deceased. There's the issue of reputation of the family, and I make a reference to a European Court of Human Rights decision of Putistin versus Ukraine, where it pointed out that the reputation of the deceased may affect actually living persons. And in this one, I think the issue was that somebody made an allegation about somebody who was deceased having participated in some war crimes, and the court said, no, you have to remember that even if this person is deceased, whatever you say about them may affect the living, because it can bring these issues of embarrassment, anger, issues of defamation. So essentially, what you're saying is that preserving the memory, the reputation of the deceased is actually quite important, protecting their families or their heirs from harm, protecting them from experiencing trauma on and continuously. And this comes to relates to their private communications, their health records, intimate photos, deaths in details, because they keep resurfacing on the digital platforms. And in Kenya, actually, Article 10 of the Media Council Handbook on Reporting Terrorism actually prohibits the publication of obscene or vulgar images of dead persons. So the people regulated by the Media Council, these are journalists or media practitioners, are stopped from posting or publishing mutilated bodies, bloody incidents, aborted scenes, so as to protect, of course, the dignity of the deceased, and also to protect the people who are left behind. I mean, their close family, friends. But essentially, what I'm saying is that once a person has passed on, their data that is online in digital form may be used by criminals to open credit lines, commit tax fraud, impersonate the deceased, because the deceased cannot monitor or defend this form of misuse. So then the issue arises is that now how can we uphold the individual autonomy of the deceased of this person once they died? So one of the proposals that I make is to uphold individual autonomy even when one passes on. I make reference to the Law of Succession Act that provides that any person who is of sound mind, not a minor, can freely dispose of their estates however they wish. And so long as this is reasonable and does not curtail the enjoyment of fundamental freedoms of ours, you and I have testamentary freedom under the Kenyan Law of Succession Act. So what I'm saying is that when we read Section 27C that says that a right conferred on a data subject may be exercised by their duly authorized representative, then I'm saying that we can, when we make reference to the Law of Succession Act, then a person has the freedom to decide that after their death, what is to be done with their personal data, how the data protection laws or privacy laws should deal with their digital, what we call their digital remains. So I'm saying a will can be a method in which somebody who is alive can seek to control how their data is handled once they pass on. And also, I say my proposal on using the Law of Succession Act, Section 27 of the Data Protection Act, and of course, Mwaniki versus Attorney General that I mentioned earlier, is that this can be a form of protection. And I also make reference to the revised Uniform Fiduciary Access of Digital Assets Act of the United States, which provides on how digital assets are to be handled when one passes on. So I'm saying these digital assets have personal data. There is probability of causing harm to the deceased and also the loved ones of the deceased that are left. So this act, which is abbreviated as RUFADA, it provides that one can identify a primary authority to handle their digital assets when they pass on, like the Facebook legacy contact, and that the custodian of this data is obligated to provide control to the legally identified representatives of the person's estate. So there ought to be a process. So I'm not saying that it automatically, but the law should provide for this legal process. And I'm saying you comparatively looking at this U.S. Law that provides for control of digital assets, borrowing, of course, looking at the Law of Succession that provides for testamentary freedom, Section 27 of the Data Protection Act, and the decision in Mwaniki versus Attorney General, then we can conclude that our Kenyan law is that the digital age, it compels that we need to rethink how we engage with death and memory, and how we engage with personal data of somebody once they are deceased. And that while in Kenya, the law is that some personality rights extinguish upon death, but we cannot remain insulated to the realities, the risk of posthumous harms, and the social value of protecting the survivors. So looking at the digital revolution, social media platforms, and the economic and emotional weight that digital assets bring, it makes the thing that posthumous privacy is a pressing concern that needs to be taken care of. And ultimately, navigating the digital afterlife, as I call it, it calls for these deliberate statutory and policy innovations. And the policy innovation that I refer to is, like, for example, as in the countries that I identified, but also saying that I argue in different sections that even without reform of the law, the issue of testamentary freedom, paying attention to Section 27 of the Data Protection Act, and relying on Mwaniki versus Attorney General, then we can say that somebody can take steps to control their data once they pass on. Thank you very much.
Well, thank you very much, Dr. Laibuta. And I think that's the conversation we were having yesterday about how typically Africans, we fear to plan for death, yet it's just close to us even wills, we don't write them. Even when we don't write them, we don't update them, things like that. Very interesting questions. I think yesterday we had a conversation of the same. Rachel was discussing the same for Africa. She's Rachel Magege from Tanzania. And there were quite a number of questions there. And I think Lingwe, maybe later we can see how the two can have a conversation together on that. And I think most important for me, the question that you came out is, can the deceased be defamed? Very interesting. And also, how can someone using succession or administration of estates deal with the issues of data? If someone does in their will and the probate, discuss how their data is going to be transferred and the rest. Very interesting concepts. So colleagues, if you have any questions, but just to say that the questions should also support to the development of the paper or critiques. But I also understand that this question and this discussion about how to handle data of the deceased, but also there are categories of individuals, of people, persons with disability, especially mental disability. How do you handle their data and consent? And I think where we may need to have a special webinar on this issue because it's coming up and very interesting. So I'm going to open it up to questions to colleagues. If you have any questions, any insights and comments. I've already given one that probably these two papers might have to see how they support each other. I think Rachel's paper is looking at Africa generally, and Dr. is looking at exactly Kenya in terms of progress. Maybe Dr. Mine will be in terms of, I see you draw some lessons from other parts of the world. Do we have, especially East Africa, any success story that we can bank on? Either case law or courts have dealt with this issue, because usually they deal with it in terms of administration of estates. And I was here thinking that, wait a minute, this is a matter which no one pays more attention to. What happens to people's accounts when they die? What happens to their keys? What happens for an institution if your communication person, for God forbid, dies and no one knows where the keys are and what privacy things they signed up to? How do we also deal with that? People who personalize offices. Very interesting questions there. Anyone has any questions to make or comments? Doctor, if you may want to respond to that.
I think I can talk of that. Apart from Waneki versus Attorney General, that's why I said this is a case that I just stumbled on last year. And I was like, wow, okay, this is quite interesting. So they are never, I mean, even my probate, my colleagues who deal with probate and administration of succession matters, I've not found a decision where digital assets have been put on the table as for probate and administration purposes. So what I'm just saying is that I'm taking a long shot and saying, if there's been this Mwaneki versus Republic where the court says that there should be some process on access for data, then I can hang on that in argument together with the Law of Succession Act and Section 27 that says a duly appointed representatives can represent me in my data subject rights. So as I said, it's a long shot, but I'm making an argument that these are pronouncements by the courts and certain provisions of the law that we may use to make the argument that somebody can dictate how their data will be used posthumously, and also relying on legacy contact provisions of Facebook, Apple, LinkedIn. So what I'm saying is that this is not a new concept. It's just that the practice of it is not as common as we will wish it to be.
Thank you, Doc. Kelingwe?
Thanks, Michael. Yes, like you say, death is really something very very uncomfortable to discuss, very uncomfortable to talk about, even within the context of data protection. But I'm sure with the presentations, the presentation that we had yesterday and also this one, we are learning a lot. There's so much to think about. You have really forced us, Mugambi, to to think about death in this particular context. So I have a number of issues that I want to raise regarding the paper. Let me start off with the issue of conceptual clarity. When I went through the paper, what I was asking myself was the the precise scope of posthumous, like what exactly is the precise scope of posthumous privacy that you are advancing in the paper. So when we are looking at it, is it that the is it a new category of rights justified by, dignity and relational privacy, or is it a are you looking at it as a proxy right exercised by survivors on behalf of the deceased? Or are we simply looking at the continuation of data subjects' rights beyond death? So one would ask, what I would ask, like for instance, is a clarification of that conceptual foundation and the way you are explicitly anchoring this in the paper. I think it would be great to have that kind of clarity. And on the issue of looking at the existing constitutional or statutory framework and legislative reform. So when you look at your paper, you define the gaps in the Data Protection Act and also the Law of Succession Act. But I felt like you should have also shown how existing principles, for instance, issues related to dignity, the privacy, is it Article 31 of the Constitution on privacy, and also the judicial reasoning of the court in the case that you mentioned. So what I would then ask in that regard is that, are you saying that even without amending the Data Protection Act, there is room for the courts to navigate as far as recognizing posthumous privacy using constitutional interpretation? And on the issue of the other jurisdictions that you refer to, I think you do provide really a very rich comparative survey. I mean, you've mentioned Rwanda, you've mentioned Ethiopia, and others. But I think it will be great also to see which of these models work for Kenya, for instance, and why. The reason why you are bringing them in, is it just to demonstrate the differences, or you are saying that there is a workable prototype for Kenya? And if that is the case, why should Kenya, for instance, emulate whatever you decide to frame as what Kenya can draw inspiration from? In terms of, you also raised the issue of relational privacy. where you are highlighting relational harms to families and survivors, but I feel like you don't fully address the potential tension that arise between the deceased autonomy, e.g. to, delete all data and survivors' interest. For instance, preserving, it could be preserving memories, it could be a cycling of estates or defending reputations. So what I would really ask as somebody going through the paper is when autonomy and relational interest conflict, whose rights should prevail and on what basis? The other issue, I think in terms of the case, I think it's a very strong case. Although I feel like also there could be more strengthening of how you bring in the case, for instance, by connecting it to constitutional principles of dignity or access to information, for instance. And if you look at for instance, the protection of dignity, the implication in terms of posthumous respect of data, and whether the court's reasoning implicitly recognizes a form of data dignity. I don't know whether this was a correct observation, but I felt like in some sections, privacy and data protection were being used interchangeably. So I felt like there's need to distinguish these two, data protection and privacy. There is a section on posthumous, the posthumous harm section, where you give us very, very good examples around that issue. But I think we could really benefit from a clear legal framing, for instance, looking at what specific torts or regulatory remedies could address these harms in the context of Kenya that we are looking at. And also probably just in your paper, you can do a brief section on potential reforms, for instance, and probably interpret if there's room for interpretive extensions that would strengthen this section for practical purposes. Going back to the issue of relational privacy, it is, I think, a good one in your paper, but I think also a definition will be great as well to justify, like, what exactly does that mean. Yeah. Then also on the conclusion, the conclusion also, I felt like, yes, it's a good conclusion. It's clear, but also I was looking for something which is a bit more forward looking in terms of how you are concluding, whether are you going to call for an amendment of the regulations or the framework in Kenya to clarify posthumous data management, something which is forward looking, which kind of links posthumous privacy to Kenya's constitutional vision of issues on dignity, human worth, and all that. But really, let me commend you for the kind of depth, I mean, and the structure you know, that is in your paper. And even when you look at the way you transition from the Kenyan law and comparative African frameworks, I think that was well done. And also the contrast between, you know, when you're looking at the Kenyan context and the other African context as well. Yeah, so let me stop there. Thanks, Michael.
Yes, Doc.
I think I've taken this into advice. The only thing that I avoided is the human dignity, the right to human dignity, because that really opens a can of worms. Because then it might need me to discuss human dignity itself for persons who are deceased. So I really consciously steered on the issue of the right to dignity for persons who are deceased, and I focused on data protection because of section 27. So that was deliberate, not to touch arguments relating to dignity. But I think for the rest, I think that these are great comments, which I'll have a look at and see how to incorporate them.
Thank you so much, Lingwe and Doctor, for that discussion. I think we'll continue having this discussion on whether they did have a right, and issues of privacy. Very interesting. So now we're going to shift gears to Tapiwa, who's going to look at the refugee data protection in Malawi, whether refugees have any data protection at all, and how that plays out. So over to you, Tapiwa.
Good morning, everyone. Good morning, Michael. Thank you. Let me just try and share my screen. I hope you can hear me fine.
Yes, we can.
Okay. And just bear with me. I think I need it to be in full screen. There we go. Okay, thank you very much. So as has been mentioned by Michael, my chapter examines how Malawi's emerging data protection regime interacts with refugee data governance, and what that reveals about the uneasy relationship between digital rights, data protection, and forced displacement. A lot of the discussion so far has kind of like focused on, without explicitly saying, but implicitly assumes that one is a citizen of the country within which the discussion is taking place, which is not the reality in the context of forced displacement. So the central tension that I explore is the new baby that we've all been talking about, and all my colleagues who spoke yesterday. The Malawi Data Protection Act promises privacy and accountability. However, the realities of forced displacement and humanitarian contexts often hollow these promises out. This is especially pertinent when you consider what refugee legal personhood is. It's somebody who's been forced to flee their country. If you're looking in terms of the UN Convention, the 1951 Convention, they're fleeing persecution on grounds of nationality, ethnicity, race, religious persecution, a lot of very sensitive reasons why they fled their country. And if you go further within the OAU definition, events fleeing public order, they cannot return to their country of origin. They seek asylum, the inherent right to seek asylum. But so this legal personhood is something that's persistently negotiated at the intersection of administrative discretion, sovereignty interests, and international humanitarian obligations. So basically, the framing that I had initially was, while digital transformation is reshaping how personal data is governed, refugee data really remains peripheral to these reforms insofar as the local domestication of data protection acts and rights is being done. Biometric systems increasingly determine how one can access food, healthcare, education, economic inclusions, while the legal safeguards for refugees and forcibly displaced people lag far behind the technology. So in framing my paper, I basically had three guiding questions. looking at what does it mean to protect refugee data in this current digital age. How can the legal frameworks in Africa reconcile the universalist language of data protection with the fragile cohesive context of displacement, where consent is really illusory and accountability is scarce? I'll go into more detail on that as I go along. And the third one, which is basically the premise of this paper, and one which I will, just as my colleagues Ian and Violet highlighted yesterday, it's one we're approaching with a mixture of excitement, cautious optimism, but also a very healthy dose of skepticism, simply because we understand the context within which we operate. This is a very new baby that was enacted last year. We have other pieces of legislation where reform just takes a very long time. And we've just had changes in government that might affect how the so far evolving dynamics that have happened so far this year might be affected. But basically, what I'm trying to say is that, and the evolving legal framework, much as it has its own challenges that my colleagues already went into, that I won't go into again, can it embed refugee-specific safeguards that transform formal data rights into substantive protection? And I dare say, again, with cautious optimism, model a rights-based approach for Africa's emerging digital rights regimes. So first of all, just going into the legal framework itself, currently Malawi's 1989 Refugees Act remains the governing statute. Now you need to understand this is pre the 1994 constitution that we have. And so basically has nothing to do with, doesn't look at refugees as rights bearers, but more focused on border control and determining status and management of camps where, because Malawi operates a very strict encampment policies, refugees must reside in camps, which is in itself a whole topic that I write about separately. But it's really not looking at, it does not anticipate the digital infrastructures that now underpin the management of refugee populations, but migration in general. The Data Protection Act, as I've already mentioned, kind of like promises and marks a major reform. It's kind of like consistent in some respects, and others not so much, with the AU Convention, the Malabo Convention, and the Data Protection Framework, articulating the principles of lawfulness, fairness, and purpose limitation. However, just like with many other African states, Malawi has not yet ratified this convention. It has been this year, and these are very new regulations that I've just come upon, and so I briefly touch upon them in my paper, and in the finalization, I'll go into a bit more detail. But they've been further regulations issued in terms of Section 52 of this Act, which focus on registration of data controllers and complaints and investigations regulations. They've had a few information sessions. It's the registration regulations are currently on version 2, so they're not yet finalized, and the draft, the complaints and investigations have yet also to receive comments. But the one thing that is noted in there, it's like more, it's about a reactive approach where, you know, your data rights have already been violated, and then how do you address that and what that means? I explore further in the paper what that means in the context of a refugee setting, whether one can really do that. Most importantly, within these registrations, and one of my critiques is that refugee data is mentioned in Schedule C, but it's referenced as a matter of national security. There's a separate schedule that deals with sensitive data relating to health and other religion and all these other things. But the putting of refugee data under national security, although it looks progressive that, okay, we're actually referencing refugee data or refugees, the heading of security rather than a special category or sensitive personal data is problematic, and it risks reframing the governance of refugee data away from a human rights orientation and towards more a discretionary regime of national security oversight. And in the context where Malawi, a lot of issues of surveillance, I know Jimmy yesterday when he was talking about civil society and civil liberties, surveillance is a big issue. Refugees already who have already most of their rights been taken away by virtue of that. They've had to flee their country of origin. This even puts them in a more particularly vulnerable and precarious situation. So the Refugee Bill, the Refugees Act itself has been under review and reform for a very frustratingly long period. I've written extensively elsewhere on this topic, but the reform process dates back to 2005. However, at the moment, we seem to be in a very good place in terms of actually finalizing and reforming it and making it more of a constitutionally sound legal document, but also one that aligns with international legal instruments. Currently, there are ongoing stakeholder consultations, and these are expected to conclude in 2025. There's a draft bill that's before Parliament, which I'm still trying, and colleagues, we've been trying to get a draft of it, but the initial version that we saw did cover the use of biometric systems, but did not really offer any guiding principles or guidance on consent, retention, or cross-border transfers in terms of the data. So what we have is a situation where we have two frameworks, the refugee law and the data protection law, operating in isolation currently, leaving a regulatory gap precisely where it's most needed. In terms of case law, generally our judiciary has yet to meaningfully engage with the information and technological dimensions of privacy. Actually, a lot of the times that it's come up in the context, and I go into more detail on this, is it's to do with national security considerations and the case does not really, the two cases we had, one, a WhatsApp treason case, and the what they call the spy machine case in colloquial terms, it didn't really engage with issues of privacy or digital rights or data protection, which was a missed opportunity. But yeah, so in this context, we have no local kind of like framework to kind of like guide us. And then I've already mentioned, the act itself is very much modeled, for lack of a better word, on the Malabo Convention, but Malawi has not ratified it. And even if we do look at the Malabo Convention itself within the African context, there is no mention or specific guidance on refugee or humanitarian data guidance. I'll also just add that this is not a specific African problem. I think globally, it's something that a lot of regimes are just now are kind of like beginning to engage with. As I've said, when it comes to issues, usually people focus first on the citizens, and refugee issues become peripheral to that. So what's currently happening, particularly in the Malawian context and in a lot of African contexts, is that refugee and humanitarian data collection sharing operates in a normative vacuum where joint data collection is happening between international organizations such as WFP, UNHCR, Red Cross, and national authorities. And accountability is really governed through data sharing agreements and not necessarily independent oversight. And at the heart of this gap is really the question of consent. The MDPA, as with many other data protection regimes in the region, assume that individuals can freely agree to data processing or collection. But in refugee settings, this consent is really illusory. If the only way, like imagine you're fleeing across the border, something has happened, there's a war in your country, you flee, you meet the first immigration officer, they tell you they need your biometrics, or whether it's an international connection, you need your biometrics, you need all this data to be able to access asylum, the right that you have. You're not going to say, no, I'm not giving you that, because at the end of the day, that's the only way you can access the system. So, and other authors have referred to this as consent under duress. It's not really a meaningful consent, and refugees end up centering it with no meaningful agency over its use or storage of information. And as a result, these conditions often undermine the principles of legality, necessity, proportionality, and purpose limitation. And I go into a bit more detail on that in the paper. And again, when we talk about the risks of surveillance and secondary use, should the data be disclosed, especially in this instance where there's no really national governing framework to kind of like oversee how this is being governed, the risks become higher. There have been issues which I can't go into detail, but where, like, you know, if there's a fingerprint issue, you might be excluded from services if you don't have your if they're not able to read you, then they have to conduct the other formal ways where they'll verify your identity, which includes a whole bunch of interviews. But until that process is resolved, it means you can't access the services that you need. I also touch upon the particular situation and the vulnerabilities of like women and girls, and especially unaccompanied children, like gendered vulnerabilities, which have also been referenced by previous speakers, that the digital inequality. And in refugee settings, especially, we see it often that sometimes, usually it's the head of household could be a man who does all the registration for the family members, and information is shared, not necessarily with women's consent. Single women might be at more risk, and especially in income settings, depending on the data that's shared. If this is disclosed, they'll be more at risk of potential human trafficking and things like that. If people see that, okay, there's a single woman living alone there. There are also instances of unaccompanied children who really, how do you gain consent of a child who's fled from a war and has arrived and has no formal guardianship. Under this section, I look at how within the Malawi law, domestically, the Child Protection and Justice Act does provide for guardianship principles. But really, in practice, this doesn't apply so much in the refugee setting or in the camp setting. And what you find is that organizations such as Unity and other NGOs kind of like act as guardians and local parental using the best interest principle to kind of like consent on behalf of children. But basically just highlights the limits of the DPS rights-based model when transposed into refugee context. And I'll just highlight that Malawi is not alone in this in the African extent, like in terms of even putting specific gendered language is one of the criticisms that even an earlier draft of the Malawi Data Protection Act, a bill, when it was still a bill, it was one of the criticisms that it does not have specific gendered language. And a review, at least on my review of research, it's not the only country. The exception that I possibly saw was the SADC model law on data protection, which explicitly includes gender within a list of sensitive categories. And I propose that within this, it was a missed opportunity that the Malawi Data Protection Act didn't include this. A second issue that I explore is the transparency deficit. Basically, this comes around the issue of data protection impact assessments. The MDPA mandates that data protection impact assessments should be conducted where processing poses high risks to individuals. So by definition, collecting biometrics and by the data that refugees have to provide would fall under this. And again, controllers must document these risks, identify safeguards, and consult MACRA, which is the Malawi Communication Operations Authority, that is the Data Protection Authority, when residual risks remain high. I'll go into separately the issues with the MACRA's, and I think my colleagues also mentioned it yesterday. There are a lot of issues with MACRA's capacity to be the institution that has this oversight, or in terms of its capacity to even be able to kind of like comment on whether these risks have been properly identified or addressed in the context of refugee. They do not have that. It's a communications and regulatory authority. It's not a humanitarian body. It's not a refugee specialist. It's not a human rights body. And one of the things that I also look at is that within this, there's no obligation to inform data subjects that this DPIA has been carried out or the findings of those DPIAs. So like I said, you come, you need access to something, you have to have your biometrics, you have to provide your data, but you're told that you need this, but there's no real obligation to tell you the DPIAs. And the Data Protection Handbook, which was issued again by MACRA to kind of like guide practitioners on how to implement the Data Protection Act in August 2024, does provide templates for reporting and guidance, but treats DPIAs as more of internal compliance tools, not really something that needs to be shared. And I went down a bit of a rabbit hole in this, but I did explore in casting that should DPIAs in humanitarian contexts be shared with data subjects? And looking across Africa, I could not see any record of any regime that has done this or published DPIAs. Within Kenya and South Africa, we've seen that there are templates of what these DPIAs should be, but the assessments remain confidential and unknown to affected individuals. Going beyond the African context, and this was again beyond the refugee situation, not that in the UK, they did publicize DPIA summaries, just basically outlining the key findings and the measures, especially in the context of COVID-19 when they put this new app where people had to surrender a lot of debt. And it was found that this promoted public trust. And in a situation where, and a lot of speakers have also spoken about this, where trust is a challenge, could this sharing of data protection interest assessments, the DPIAs, kind of enhance or improve trust within the systems? The Commission for Information and Liberty encourages summary disclosure of DPIS for high impact projects. So I analyze a little bit the desirability, the capacity of this. And what I conclude is that I think, given the capacity challenges and other issues that would come about it, given detailed DPIA assessments, making them public or sharing the subjects with the involved data subjects might not be practical, but one way around it could be just clear summaries that are in language that's accessible to the individuals, to the refugees, that can be shared within camp setting or in settings where the refugees are based, just to kind of like give that assurance that a DPIA has been conducted and the risks have been assessed. Another regulation as referred to is that it is the registration regulations, which require that controllers or processors of significant importance should register with MACRA over 10,000. That's if you're processing data of over 10,000 individuals, you must register. Given that there's over 50,000 refugees in the country, this would put the Commissioner for Refugees as a significant controller who needs to register with MACRA. However, the question that remains, and that's not very clear, because registration, as I mentioned earlier, is usually jointly done. It's not just the government entity, so usually and in the Malawi context, it's a joint UNHCR government exercise. Does UNHCR, for instance, need to register as a data controller with MACRA, and how would oversight be exchanged in that? Basically, the other element is if any data controllers that handle categories listed as having economic, social, or security significance. As already mentioned, refugee data has been, for whatever reason, classified as a security issue, so it would fall within this. However, there's no clarity as to how, in instances where there's joint registration of this data with an international entity, how that registration would kind of work within the regulations, and there's need for the regulations to either be expanded to explain that or to clarify that. Okay, and then the next section I look at, which is more linked to the cross-border section and the discussions that have happened about that. By definition, the fact that the person is cross-border and any kind of management often involves transfers across border or into home humanitarian spaces. The joint registration exercise entails that a lot of the data is held on servers of international organizations beyond the country within which it's registered, and Malawi is no exception to this. The MDPA kind of like says this transfer can apply through adequacy determinations, something which was also talked about in Ian's presentations. However, there's no specific criteria on what this would be if it's a humanitarian actor. The determination to make an adequacy it should be done by MACRA again, which has its own institutional challenges, and that might assess adequacy by country, region, or sector. And it provides a number of mechanisms, including the presence of data protection laws equivalent to Malawi standards, binding corporate rules, contractual clauses, approved code of conduct, or certification mechanisms. However, as we've highlighted, given that the data protection age is still very much in its early stages of implementation, there's currently no adequacy assessment, to my knowledge, that has been done or published. And again, there's no specific governing criteria of humanitarian actors who also would, in a lot of instances, process data in a lot of like cross-national. This can be done sometimes. Usually we see instances of where, because of flight, one family member ended up in Zambia, another family member ended up in Malawi, and there's need to kind of like do family reunification across the borders. And the Data Protection Act does mention transfers when it comes to state entity. But as I've said, there's also a lot of actors involved in this, like the Red Cross and whatever, especially when it comes to family reunification. And it's not very clear. There's a bit of a lacuna in terms of how the oversight would be handled in that side in the domestic sense of things. And MACRA is allowed to make the adequacy assessments on application by a controller on its own initiative. But as I've said, I have not seen any such adequate assessments being done. Data is already, though, and not just in the refugee context, is already circulating. I did look a little bit about the comparative insights in terms of how Kenya has been approaching this, which noted that it's a little bit more flexible, in my opinion, that because it allows human transfers based on public interest, whereas the Malawian one focuses more justly on the adequacy assessment. And then in terms of whether domestically one can have jurisdiction over the transfer to an international organizations, I did look at the Ugandan's 2024 PTPO ruling against Google, which affirmed the extraterritorial reach of the local act requiring global actors to meet domestic standards. And I argue that Malawi could draw from this approach to enable it to hold international organizations accountable for refugee data exported to global servers. Okay, I've touched a lot on oversight and accountability, and I think colleagues have also referred to this. MACRA is really not is not well equipped to handle issues of humanitarian and human rights data transfers. It is a technical oversight mechanism with communications and regulatory. And so what I propose within this is a hybrid model where the different entities that could be involved in humanitarian data processing could be done. I've already mentioned the Commissioner for Refugees, who would be the ideal data controller and would be responsible for the operational side, and MACRA could come in on the technical side. And I further propose that the Malawi Human Rights Commission could, because of its human rights mandate, could oversee the process. For instance, in the recommendation that I've made about DPIAs being published, summary DPIAs being published in camp settings, the full DPIA itself should be not just be shared only with MACRA. I think the Human Rights Commission should also have access to that to ensure that the adequacy assessments and all these things have been done properly. And within this, I also look at how Uganda and Kenya have adopted this to see if there are any insights that Malawi can take. So basically, I have a few concluding reflections on this. Running out of time, so I'm quickly going through this. Basically, it's the discussion we've been talking about on the last 2 days. With formal rights, absent considerations are insufficient. Data protection are often drafted in universalist terms and assume stable citizenship, voluntariness, conditions which are absent in refugee contexts, which are defined by dependency, and one would argue coercion. And protection today must be understood as both physical and informational. And my recommendation comes that embedding refugee-specific safeguards in the upcoming Refugees Act, hopefully this time it will actually be finalized on time, would help bridge this normative divide between the MDPA's general principles and the lived realities of refugee situations. And this would not just be a technical reform, but a normative shift that views data protection as not just as a compliance exercise, but recognizing it as an intrinsic component of human protection. And I argue that in doing this, it could put Malawi in a position where it becomes one of the first African states to kind of like legislate directly on humanitarian data governance. I also make 4 recommendations, which I've already touched upon, on lawful basis for processing, recognizing that consent is illusory, strengthening cross-border transfers by really regulating or defining further how international organizations interact with domestic legislation. And in the humanitarian context, I argue that really DPIAs should be mandatory and should not just be regulated to high-risk cases. Thank you. That's, in summary, my paper.
All right, thank you very much, Tapiwa. That was very interesting, especially on the issues of data for refugees. And 2 important points for me there is, I think for me, is the issue of conditional consent. How far does that go in terms of protecting the refugees, but also in terms of their data? And then number 2 for me is there an end to this consent? Is it let me use the word implied that, once you come here, just sign here and go, or, get the services, will come back to you later. Is it perennial? Is it, are there instances where people have to consent to their data collection in periods, in phases, or once you've signed, whatever information we get from you, because the assessments to do, how much food they need, health issues. But lastly, I think for me is a bigger question for all of us here: data in emergencies. It may not be refugees, maybe something else. How do we handle data in emergencies? This could be accidents and all the others. I think it's a good teaser for us to start thinking about that. And lastly, for me, Tapiwa, is the issue of so from your analysis, does the law in Malawi, I see you give some recommendation, that does it give an express position on the consent for the refugees, or does it have nuggets of, even when you collect it, impliedly or in a bit, how do you store it? Because there is also the issue of balancing between what we do. These people are here, we need to get their data, and people use their data for many things, for asking for donations and all that kind of stuff. So those are the few that I could put up across, but thank you for that very interesting discussion. I think it takes us to issues of how do we manage data in emergencies. Thank you. Anyone else has something to discuss? I know, Hellingway, you come in, but I want to see if there's someone else who has some comments to put across. Okay, as you do, Hellingway, are you ready?
Maybe let her respond to your questions first, so that we don't overload her with the issues.
Okay, thank you. So in terms of the conditional consent, as I kind of like highlight in the paper, currently there's no legislation within Malawi that governs the issues of when refugees can consent, how the data is stored and managed. As I've said, the Refugees Act that currently is there, the focus really is on determining your status, are you a refugee or not, and the procedures towards that, and in terms of camp management. So at the moment, kind of the principles are guided in under what we call the UNHCR policies, because the registration is done jointly between the government and UNHCR. So the policies within UNHCR does have its own data protection policy, which kind of like applies and is kind of like embedded within the data sharing agreements and MOUs that are between the government and these entities, but there's no other independent oversight mechanism to kind of like review this. So it's one of those things that it's not a one time, because there's always there's always times when there's and I go into a bit more detail in the paper on this. There's continuous verification exercises to make sure that your family status is still the way it was. But also, I touched upon a little bit of how Malawi has a very strict encampment policy. So you always have times where, like, I think the most recent just happened before the most recent elections, where government authorities will go around town and round up people, round up refugees and asylum seekers and take them back to the camp. And through that, like, the information about them is being conducted. If there's no really consent, it's like you should be in the camp. And there are all sorts of risks that come with that in terms of surveillance and making sure that you're not where you're supposed to be. So the basis, you have in this instance, so what we've been guided by is there's the Red Cross handbook on data in humanitarian context, which would apply within the emergencies. And I saw that the name is escaping me now, but and I do touch upon his research in the paper, where the group data is being collected and profiled, and how, and he also touches upon how the data protection regimes, not just in Malawi, but globally, kind of like the focus on individual rights kind of like does away or misses this other part, which would apply in emergency settings. I did not go into too much detail on it, because my worry was that then that would take away the focus from where I'm trying to propose a potential way of harmonizing this gap that happens. And something I didn't touch upon in my presentation is my personal view, and I'd welcome views from colleagues, is that expecting the Data Protection Acts in Malawi or in any other context to kind of like address all the different human rights or humanitarian issues, either through legislations or the paper itself, is kind of like setting up for failure, and that it has to be, again, I talked about the hybrid model in terms of oversight, but I think there's also need for a hybrid model in terms of the legislative framework. And that's why in this instance, it finds itself in the Refugees Act, which is currently under revision. It hasn't talked about, the last draft I saw doesn't talk about consent, but putting in all these principles of human rights, right to privacy, moving away from the procedure side of status discrimination and more about what rights should refugees have under this act, is one way of bridging that gap and ensuring that data protection principles also apply to that. And I dare say that could extend insofar as whether you're talking about disability rights or child protection rights. I hope I've answered the question. Thank you.
Yes, thank you. Lingwe?
Thanks, Michael. I was hoping we would get somebody else to somebody else to speak, or if we have somebody with more expertise around refugee issues. So, but let me go for it. What I have are more of recommendations that you can consider as you revise your paper. First is the issue of consent. The issue of consent. I mean, when you're looking at data protection generally, consent is kind of a cornerstone for data protection. And I think in the paper, you need to clarify how meaningful consent can be operationalized. I mean, if you're looking at the context of refugees and the issue of the reality that some of them may actually lack, genuine choices to make informed, meaningful consent. I think that issue I thought is something that can be clarified. Also, you do, which I appreciate, make reference to South Africa, you do make reference to Kenya. But I think also you should have a bit of a deeper comparative analysis with international standards, so that you situate the Malawi reforms within a broader normative landscape. So we have the standards within the UN context. We also have within the African context as well. So I thought that is necessary. And then in terms of oversight, yes, I hear you mentioning some of the authorities that exist in Malawi. Probably you need to elaborate on institutional conflict of interest, for instance, procedural safeguards that can be adopted so that oversight there's effective oversight. I mean, including institutional capacities as well, beyond, I think, what you've done. But I just think a bit of addition on these issues. Then there's the issue of state security. The issue of state security, which is something that you can't avoid when you are, writing a paper on this one, on refugees and data protection. And that tension between the state security and privacy is it's an important theme. And I think the article should clarify the limits and safeguards that would prevent probably justified security measures and overriding refugee rights. Then there's also the issue of looking at refugees that are existing outside of formal establishments like refugee camps, or those ones that are undocumented. And I mean, looking into the fact that, data protection frameworks often rely on formal registration systems. I think the paper can consider discussing data protection challenges for those in informal settings, and those that are not covered by, for instance, biometric systems. And then the issue of cross-border data flows and the involvement of international humanitarian agencies. This is really an issue, especially in circumstances where now humanitarian aid is required. And there are also, issues around accountability, issues around remedy for data breaches or data misuse. So I think more detail is probably required around the issue of legal frameworks governing transnational data transfers and mechanisms for refugee data subjects to seek redress across jurisdictions. I wonder whether we have anything around that, whether UNHCR, for instance, has developed something around that. If there isn't, maybe that's an opportunity in the paper to frame or to make some proposals around that, but having looked at what the challenges are, and then one can frame recommendations there. Yeah, I think those are the issues that I can bring about at this moment. Also, the issue of some of the concepts, I think you mentioned them, I think, but you need to define them. For instance, informational self-determination. I think that is supposed to be defined. Also, some terms such as cohesion in consent as well. And then also defining the scope of refugee data, what types of data are covered in biometric, health, location, communication, and how these categories raise distinct also legal or ethical concerns. Yeah. And then I know we've spoken about the Malawi framework being a baby. I think you have covered that very, very well. And then also I think you make reference to the Refugee Act, which is like it's a 1989 piece of legislation. So I think it's now updated. There's a lot maybe that needs to be relooked when you look at the refugee law as it stands now. Yeah, I think that's it.
Okay, thank you. A lot of food for thought. And I think maybe just to respond to a few of the elements, and definitely, I think this part about bringing in a little bit more of what the guidance has been within the document. I do touch upon the different guidance documents and kind of like framing how they could be a guide in terms of how, when we're updating the Refugees Act, how that could come in. But I do take note of your point that to go into a little bit more detail on that. One of the challenges I had was also operating within the word count that this chapter is supposed to have, but I'll see where I can cut a little bit and bring in a little bit more. I'm just sorry. As part of photos. Yeah, I think all the elements you've mentioned, just looking at the notes again, see how to kind of like expand, because I do touch upon them while still also staying within the word limit that is provided. I'll just review how to do that. Thank you.
Yes, indeed. I see Mugambi's hand is up, and he also has a comment, you know, on the. Anyway, let me ask. Let Michael, with your opportunity, with your permission, if you can allow Mugambi to come in, and then I can respond if probably there is need for clarity.
Okay. Thank you, Tapia. So mine is just practical from an experience working for a humanitarian agency. So like in Kenya, there are these refugees. They're in a camp in Ethiopia. They go to hospital in Kenya. You get so they're the border point.
Yes.
And then there's that challenge. I don't know whether you've considered it, because it's something we are grappling on. How do you deal with this situation? Or they're in the other side of South Sudan. They go to school in the Kenyan side, but essentially they are refugees, or vice versa. So that then it becomes a challenge. Then secondly, another challenge you face is how do you get the humanitarian agencies to be accountable? Because some of these refugees, the humanitarian interventions, they sign up to different humanitarian agencies. You find that in a family, so that they can get, like, for example, these cash transfer programs, they will register with UNHCR, they will register with World Vision, they will register. So you find that a family gets interventions from all this, and the data is with all these communities. So there's that. There's no centralization of how this data is handled. So we tried having a data stewardship kind of process. Of course, it collapsed because of the politics around all that. So just thought just to throw that in, because it's a practical experience we faced, and it was really challenging to think through that.
Okay, thank you. I'll start with the movement between countries, because I also work in the space, and it's one of the policy advocacy points that we've been making, is that actually, excuse me, refugees should be able to move across the borders. The important thing is that they should be documented and be able to access. And it comes down to the whole element of economic and education inclusion. As you've mentioned, they either move they're in two different countries. They're not, as long as they're not going back to their country of origin. The regulatory system should be such that if I need to go sell my items in South Africa, but I need to go across the border in Zimbabwe to sell items, I should be able to do that, and I should be documented. And then there are systems in advanced places where you have, and I think Kenya is one of them, there are actually convention travel documents that are issued to refugees, and the IDs that should be able to show them that, you know, they're moving. Yes, I'm coming to Sudan for this purpose, but actually I'm a recognized refugee in this other country. And it's a topic that I could write a whole separate chapter on in terms of those movements. It's another angle that could come in. But because here I was focusing more on how the MDPA is kind of like applying this context within Malawi, I didn't go too much into that. But definitely I do touch upon the issuance of travel documents and what risks can emanate when moving around in that instance. But basically, again, it also reaches out to the point of data being held in international servers by humanitarian organizations, because one of the things, at least from a UNHCR perspective, is that it's one database, it's a global server. So whether you move from Kenya to South Africa, for instance, if you're registered in both instances, the biometrics would show that you've moved and you're in this location, and you're able to, one of the ways we manage it is when people are moving, as the question is your intention to move permanent, or you're moving to go for a specific purpose, as you've mentioned, education, health purposes. The rights regime is such that refugees should be able to move that, provided it's documented. And actually what you're aiming for is to ensure that their protection is maintained and they do not risk being sent back to a country where they'd be subject to persecution. So that's one way, at least, that can be handled. I do realize it's not so easy, but I think recognizing that the rights to being able to move around is one of the ways that protection can be provided to be economically active and you're not dependent on humanitarian aid is one of the areas to do that. how to hold organizations accountable. I looked at this in the paper, but not necessarily in the context of services being provided in different instances, but in terms of data being in terms of how MACRA in itself is limited in its ability to exercise oversight where data is being transferred across borders in movement when things are happening. What I do know is that, and it's something that I do touch upon, and probably I'll expand a little bit more on it, is a lot of these arrangements, they should be institutional. They are, in most contexts, data sharing agreements. So the entities that you're talking about, normally there are data sharing agreements that would regulate when can, for instance, if it's Red Cross, transfer data to save the children in the context of a child protection issue. The regulations, the codes of conduct within the organizations and their data sharing agreements that do operate on this. But as I expand in my paper, these are operating in a vacuum. They're not subject to regulation within the domestication. And when I looked at research in the humanitarian space, really, there's very limited instances of guidance. We do find guidance in more the commercial space, and that's why I was looking at the judgments of the Google judgment, which basically said, look, you're an international company, but what you do, you can be subject to domestic legislation, to see if it's something that Malawi can kind of like use that guidance to, in addition to the normative and the international obligations that everybody has signed to and the documents that are there, to see if it can guide in maintaining oversight over those kind of processes. But I do agree, and that's basically the main purpose of my paper. There's this tension. You have this data protection. It looks very good on paper. You have these international agencies. They all have different codes of conduct with very different standards that are operating to provide data protection for refugees, but they're operating in a vacuum. Meanwhile, the person who's the data subject, the refugee, really has no meaningful say in how this data is getting moved and being done. There's the accountability side on the part of the agencies, but there's still this gap where the data subject himself, his own rights, has no real agency over how that data is being used or being processed. And it's one of the things that I'm really looking at into this paper to see how. And as we're talking, I'm already thinking of a second paper that could probably come out of this. But yeah, very interesting stuff. I see Hungary has her hand up again.
Yes, Tapio, I'm sorry. I'm wondering whether your paper clarifies how biometric and digital registration systems actually function on the ground, and if it does, whether you then went on to discuss, the risks or challenges that arise for refugees.
Yes.
It does. Okay, that's great.
Yes, it does. Yeah.
And then also,
as I said, my challenge now is how to incorporate all this within that content. But yeah, that's big. Yeah.
And then also, I'm also interested on the what is it called, social political context that shapes refugee data governance.
Can you expand on that?
I mean, when you're looking at issues such as, language barriers, mobility restrictions, power dynamics.
Yes.
That. Okay. All right. Then that's fine then.
I do touch upon it in the context of when I talk about how within the Malawi specific situation, the linguistic and cultural barriers on consent. And then I do talk about it in terms of the risks of surveillance, but also how the right to privacy within Malawi jurisprudence so far has, where issues have, and the part of forced encampment, and how almost every year there's a roundup where people are routinely rounded up, taken back to the camp, with data being collected in the most, a very coercive element, and the whole security thing that the government hides behind. And basically looking, and it's the critique that I make on the regulations themselves, the draft regulations that just came out in July. So they're still currently under debate, but basically there are 3 schedules within those regulations. In part A of the schedule, you have what they classify as sensitive data. This is data dealing with your health, your nationality, and other, the sensitive data. But when it comes to refugee issues, this is put under Schedule C as a national security issue, which again, my argument is that we're basically going back to the pre-constitutional era where the focus is on refugee issues being a security issue instead of refugees being rights-bearing individuals.
What is the main contribution of your paper when all has been said and done?
Basically, what I'm saying is that should the Refugees Act be reviewed and adopt all these data protection principles, it would be one of the first within the African continent that would actually directly legislate and could provide a model, given that within Africa at the moment, from my research, there isn't a similar provision or there's a similar domestication of how to handle refugee data protection rights. So basically it's to say that while we're dealing with this in this infancy as Malawi is emerging and is developing this framework, both pieces of legislation provide an opportunity. Again, the baby, if developed properly, you could provide a model that other African states could come upon. And then I make recommendations of how that can be done.
So the baby that you are talking about came up with this challenge. So are you proposing an amendment to the law? The Data
No,
Protection Act?
no, and that's precisely what I was saying from the beginning, that the regulations, not the law itself, but the regulations that are now currently in draft form need to add a few more elements of how they interact with humanitarian data, but it's insufficient. It's almost impractical to expect the Data Protection Act to be able to govern all that, and that there needs to be a hybrid system where other pieces of legislation, and in this instance, that's the Refugees Act, kind of like embed those protection principles. And I go further to say that this might not, I mean, that's what I was mentioning earlier here. This is a situation of refugees that I'm proposing, but it could very easily apply in the context of child protection rights or other disability rights where the data protection acts that we have do not necessarily speak to these vulnerable, specific vulnerabilities of data subjects that can now be addressed in specific legislation that deals with that particular subject, but with regulations that speak to the data protection elements.
I think we can go on and on. That's fine for now.
I'm glad it's generating this discussion and with a lot of food for thought, so I will bring it up.
Thank you very much, Tapiwa. That's a very interesting discussion. I think, like Helingo and others say, this can go on and on, but very important to look about data in the context of emergencies and refugees. And in some contexts, data and access to information is restricted to citizens. And then when you have refugees in a country and they are not citizens, then how is that, how does that play around? Very interesting insights. So thank you, Tapiwa. We can give you a virtual clap. We now going to take a break so that we be able to do the last bit of it. And so I'm going to ask that we take probably a 10 minutes break so that we are able to catch up with time and also finish in time. So we can take 10 minutes break and resume at 11:50 for the next round. And we hope that by 1 p.m. South African time, we'll be done with this discussion. So thank you, everyone, and see you in 10 minutes. Yes, good morning to you all. I hope that you had a simple break to grab that water and stretch a bit. So that we proceed and have the last leg, which will focus on geopolitics, sovereignty, and surveillance. And we're going to have Dr. Aaron Salau, who will go first to discuss China's cybersecurity norms in Africa. And Dr. Salau, if you are available already, you could take it away. I saw Dr. Salau. Yes.
Yes, good morning. Good morning, all. I'm going to have to change my to my laptop now. So just give me a couple of minutes to do that. So because we have some issues with power here, so but I'm trying to make myself available. Okay. Just trying to get there. Let's see. Okay. Okay, maybe what I can do now, maybe I can start the discussion and then maybe when I transit to then you will see my slides. Okay, let's see. Okay. Yeah, I'm trying to launch the Zoom application. I think this thing is taking longer than I expect. Just bear with me. Okay.
You can also email the presentation to Michael. He can help you with the slides.
Okay.
He can assist you with projecting the slides.
Yeah. Okay. All right. Okay. So, but okay. I don't know. This is gonna take. It's taking longer than I expect. I thought we were going to have some discussions after the last session. So okay, all right, okay, okay, okay. 3079. Oh, sorry, 378. Oh, so sorry about this. Okay. Recording in progress. Okay. Can you see me now? Okay. Yeah. Sorry for. Yeah. 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 Okay. I think the second machine is making an echo.
Yes, Doc, if you can mute the second machine, then it won't be able to give you the echo.
Okay. All right. Okay. So, I hope you can see my slide now.
No, we don't see it.
Yeah. Can you see it now?
No, we don't.
Oh, what's going on?
You can also in the meantime email it to me so that you can proceed as we sort that out.
Oh, okay. I've seen what happened. I think my internet just went off. I think that's what happened. So I'm just gonna come back on stream. Just now. Okay. Sorry, so sorry for this. Okay. Recording in progress. Okay. Okay. So can you see it now?
No, we don't see
Yeah.
it, Doc.
Not yet.
No, we don't.
Not yet.
Doctor, could we probably ask Christopher to present as we sort that out with you?
Okay. So no, that will be fine. Yeah. Okay. So no.
Yeah, so we can allow Christopher to present as we
Fine. Yeah.
we sort that with you. You can just email me your presentation, and then we can sort that out in the background with you.
Yes.
Yes. All right. So Christopher, please carry on.
Hello, everyone. Okay, sorry, I'm a bit hazy. I just thought maybe you would see that there's a person behind this. It's not AI. Let me share my slides. I'll turn off the camera so that I'm audible. And that I don't use much data. Michael, please confirm that you can see my slides.
Yes, now we do. They have finally appeared.
Okay, thank you. I know technology sometimes plays tricks on us, and some of the things that we don't anticipate happen, especially in this part of the world. And we're talking about digital sovereignty, I guess, because these platforms are not in our total control. These hiccups do happen. And so this is quite relevant as an introduction to what I will be talking about. My name is Christopher Msoza, and I work in the digital space, primarily security, and now learning ethics. and issues to do with governance. I've been working in this sector for probably 20 years now. And I'm also keen on research and building on some of the theories, principles, and frameworks that are there in place. So Africa is at a defining moment in its digital transformation, and as alluded to earlier on, I think it was Ian who was presenting with similar statistics, and maybe perhaps we were using the similar sources. By the year 2025, the continent's internet penetration rate was reaching 47%, and mobile transactions exceeding 1 trillion annually. But yet beneath this growth lies a digital dependency conundrum. Over 80% of our data is stored in foreign-owned data centers and servers. I think if I were to do a survey here, all of our apps that we normally use day to day are not African apps. They are foreign apps and with data stored on foreign servers. And data is likened to the new oil, as they would say. But the question is who controls that resource? And that's the focal point of our discussion. The fundamental concerns that have surfaced regarding who controls this data and where is this data stored and under whose legal jurisdiction it falls. So these questions lie at the heart of the discourse on digital sovereignty and data privacy, not just in Africa, but for this particular chapter, we're looking at Africa. Digital sovereignty refers to the capacity of a state or region to exercise control over its digital infrastructure, data, and technologies in ways that uphold national interest, values, and human rights. So in Africa, foreign actors, particularly the US, Chinese technology companies, largely shape and dominate the digital ecosystem in the region, and the lack of local control over data storage, processing, and the platforms raises serious concerns about the privacy, security, and even strategic autonomy. The dominance of external providers exposes African states to surveillance, exploitation, manipulation, often without adequate legal recourse and technological safeguards. So digital sovereignty is not technological isolationism, but strategic autonomy, enabling Africa to harness data for equitable development while safeguarding privacy as a fundamental right under Article 9 of the African Charter on Human Rights. So in this paper, we argue that digital sovereignty in Africa is not only a policy imperative, but also a foundational condition for digital justice, economic resilience, and democratic integrity. This chapter will also argue that Africa's path to digital sovereignty, the capacity to autonomously govern digital ecosystems, hinges on dismantling structural inequities through infrastructural self-reliance, regulatory harmonization, and Pan-African collaboration. So defining digital sovereignty in the African context is peculiar because we are dependent on foreign technologies, and it has been like that for a very long time. But in general, it means that a state can manage it if we have digital sovereignty, means that a state can manage its digital infrastructure, control the flow of data, enforce rules and norms in the digital space in a way that is consistent with its own laws and interest. A few days ago, Amazon servers went down, and we saw the world screaming, and particularly in Africa, even the borders, South African border and Zambian border systems were affected, and some of our health systems were affected. And so the digital sovereignty is not only affecting data privacy or data protection, it also affects the day-to-day access to different systems that are important in our digital ecosystem. Africa is home to only 1.3% of the global data centers. And of that 1.3%, South Africa has half of those. And African countries depend on data centers that are located in Europe, the US, and China. And so even basic digital services such as email, search engines, banking systems, the private messaging, and now AI are hosted on servers beyond the jurisdiction of African regulators. And so this situation raises many legal and operational questions. When data is stored outside a country, which jurisdiction applies in cases of a breach? Who is responsible for ensuring data protection compliance? How can African citizens redress for violations committed on foreign platforms? I saw that there's a lot of data on this slide, but it gives us a picture of estimated users in Africa by platform. Facebook, we have about 15% of people on Facebook. I have issues with data that we got from a portal called Data Portal online. I think the WhatsApp number should be a bit higher than the Facebook number. The Facebook number, the Facebook 15%, 15.2% is accurate because it's actually generated by Meta itself. When you try to make an advert and you say you want to reach the whole continent, it gives you that number of 465 million. But this number does not give us the true picture or the only picture that's important. Many of the citizens in Africa, many of the entities in Africa are data subjects. And so the impact is actually bigger than this. And Africa is a growing populations. If Facebook wants to grow its platform, if WhatsApp wants to grow its platform, TikTok wants to grow its platform, they look at Africa. And data being the oil, the continent is a key focus. Now we look at some of the data that is stored and that is handled by these companies. We look at Facebook or Meta in general. The biometrics, location, behavior, interest, religious inferences, GPS locations, the emails themselves, and then the search engines, the search queries, YouTube, the videos that people view, maps, obviously the location of different individuals, and WhatsApp. There's a lot of metadata that's there. Of course, they say the data is encrypted, but the messages themselves, and then TikTok from ByteDance, it keeps a lot of information that is useful for surveillance purposes. Now, because these companies have access to all this information, it is possible, like for example, Google, to make inferences, or someone who has access to Google data to make inferences. If I am searching about diabetes every day, and I'm looking at websites that are to do with home remedies about diabetes, or I'm looking at how to, well, the impact, the effects, the side effects of insulin, it is possible then also to infer, and given that most of these companies also have AI systems which are linked to some of the to some of these platforms, there's a lot of inference that can actually bring more private data to, access to people who should not have access to it. And if you look at the terms and conditions of these applications, all of them, if you analyze them, they are designed to comply with American laws and also the laws within the EU jurisdictions, and not the specific localization. I'll touch on it when we look at the slides that follow. So related to this, most of the platforms and cloud services that are used across the continent are run by US-led tech systems. Companies like Google, Meta, Amazon, Microsoft, and the Chinese companies primarily run the infrastructure that runs the telecoms, what we call the pipes. And so we are basically reliant on these foreign entities to run our systems. As I alluded to earlier on, when Amazon was down, the border control systems were also affected. So while these investments are important and they keep our companies running, they keep our systems running, I can imagine spending a day without WhatsApp. It would be very difficult. The technology itself has brings us to sovereignty and data privacy concerns. Reports have emerged, for example, the African Union data breach, or when it was alleged that African data was being siphoned off by Chinese servers. I'm sure the next presentation is going to touch on this. I will not elaborate too much on this. But I also mentioned the fact that many of the entities like Google, Facebook, and so forth, they are data companies, and they are in their interest is data and advertising, and some of their data is sold to research entities without consent, or maybe consent is given when you accept terms and conditions. The terms and conditions that we accept, we normally, well, in my other life, I'm a tech person, and I tell people, if you want to install this app, you need to accept the terms and conditions so that you move on to the next step. We rarely read the fine print and the legal jargon that sits within the conditions do actually specify some of and do cover some of these entities regarding this. And the terms and conditions make them compliant in Europe and mainly in the US, and China also has made some demands to make sure that these entities are compliant. So American platforms are dominant in the region, and not only in Africa, but to be fair, even in other countries as well, globally in Asia, and etc. But the algorithmic governance, clickbait, and false information, and data harvesting practices, they've raised a lot of question marks. We have seen concerns in the US that has surfaced about TikTok, the Chinese-owned company, owned app that is owned by ByteDance. We've seen them, the Americans raising concerns about TikTok, and that already shows you that some of these apps have geopolitical impacts that we might not anticipate. So looking at further, as a critical aspect of foreign dominance is the extraterritorial reach of the foreign laws. There is a software system called PRISM that was mentioned by Snowden in 2000, I think some 10 years ago, maybe 20 years ago. In 2007, that's where a system called PRISM began, that is run by the National Security Agents. It's a mass data collection system for surveillance. It collects from various entities that are owned by the American system. And most of these, the surveillance itself, it relies on a number of legal instruments, and one of the key one is the Foreign Intelligence Surveillance Act. And then also there's also the Clarifying Law for Overseas Use of Data Act, what they call the Cloud Act. So the FISA and Cloud Act are the main extraterritorial laws that are used for surveillance purposes or data collection in the US. But there's also national security letters that are issued under the US Patriot Act, and other intelligence directives that compare US registered entities to disclose data regardless of where the server is located. And so these pieces of legislation empower the US authorities to compel American technologies companies to provide data stored on their servers. And this is and this legislation has no direct mention of the specific data protection authorities, the respective data protection authorities, or the data protection laws that are in specific countries. And many of our African states, they lack the comparable agreements or legal tools or bargaining power to compel access to data stored abroad by foreign providers. If you look at the transparency report, glean on transparency report, Google transparency report, you can see that there are many African countries that have attempted, for example, to request data from Google servers. I looked at Kenya. Last year, Kenya made a number of requests, and Google did not honor any of those. Kenya, Nigeria, I looked at Zambia, Zimbabwe, and even South Africa for the year for 2024. If you look at that, Google publishes the transparency report. And so you'd find that in terms of there's a power imbalance, and the imbalance underscores the even distribution of legal power in the global digital order, and that leaves African regulators dependent on voluntary cooperation of the foreign technology companies. We had earlier on mention of the case that was raised by Uganda, where the Ugandan Personal Data Protection Office found Google in breach of the country's data protection laws and ordered the giant to register within 3 days. That was sometime in July. We haven't seen the response from Google, but even the order, it did not have any fines or any specific action that would be. It was silent on the specific action, and from that we can actually see that we are not sovereign as individual countries. So we have many frameworks, quite a few frameworks that are there in place: the Malabo Convention, the AU Data Policy Framework, and different national approaches that I mentioned in the paper. Nigeria, Kenya, South Africa, and Zimbabwe, they also speak to how data is transported, the cross-border transmission of data. But whilst these laws exist, the enforcement remains a big challenge. The Malabo Convention still has 15 ratifications, and most African data protection authorities suffer from underfunding, as we were learning yesterday. And also the fragmented nature of the privacy laws across Africa is also a huge barrier to regional data sovereignty. Some countries have enacted comprehensive laws, Others rely on outdated statutes, or even have none of them. And this inconsistency hinders cross-data flows and complicates regulatory cooperation and creates loopholes. So the fragmented nature of privacy laws across Africa is the major barrier to digital sovereignty. Some countries are still to enact the laws. And we see that as one of the limitations to the national approaches. Most African countries lack the economic leverage as individual countries. Imagine like Uganda, the specific example that we have, and imagine Zimbabwe or Lesotho trying to compel Facebook to comply with its data protection regulations. It can be a bit of an ask, and these guys, the big entities, they'll throw their weight around to comply with. For example, Zimbabwe has an estimated 120,000 users who are on Facebook. And so such a number is a drop in the ocean for an entity that has 3.6 billion users. And so internet shutdowns and state overreach. So this is one of the problems that we have in terms of digital dependence. The excuse that states use in internet shutdowns is that they don't have control and lack of compliance from the respective digital platforms providers. I know this is a tough one for me to include because I'm against internet shutdowns. But the excuse that comes in is that, and we have seen more than a dozen countries turning off internet or turning off specific apps or partial internet shutdowns. Zimbabwe included, Uganda, Sudan, and there are quite a few others. And the excuse that they give is that they don't have control over the technology, and the only thing that they can do is to block or shut down the entity. So we can draw lessons from the African Union, the European Union. The European Union gives us an example of how it can be done. Perhaps there's a case for regional cooperation. In Africa's pursuit of digital sovereignty cannot be achieved through individual national strategies. Given the transboundary nature of internet, cloud services, and data flows, regional cooperation is not merely desirable, I think it is essential. Although individual governments, as I stated before, lack the bargaining power, if we have the African Union or regional economic blocks, at least, and if they can provide platforms for collective action or harmonization, it can be better. But if we draw lessons from EU, the European Union offers a very good example for how this can work. I'll state an example of the EU collective regulation through the General Data Protection regulations. It sets a high standard. There's the right to be forgotten that started as case laws, and now it's codified in Article 17 of the GDPR, and anyone in Europe can actually request a search engine to remove information about them that is deemed inaccurate or has expired. And this only works for EU. And we have seen EU fining, for example, WhatsApp, when they updated their terms and conditions, silently updated their terms and conditions, and they were fined 225 million euros because the updated terms, the silent updated terms, did not comply with the GDPR. Yeah, so there are a lot of lessons that we can learn from, and then the enforcement of the cookie consent. We have seen many websites now, they display a warning about a website using cookies. So and this is in compliance of the cookie consent that was called for by the EU, by the European Union. So there are many pathways to digital sovereignty, and my main one is having a block as to is emulating the EU model. But before we get there, to be realistic, I think we can start with foundational steps in given the way we are as sovereign states within the continent, investing in local infrastructure, trying to harmonize regulatory frameworks, uh, public-private partnerships for innovation. I was looking at the need in terms of for investing in local infrastructure, the servers that we require. Some of them would need 1,000 megawatts of power. And looking at Zimbabwe's generation capacity right now for the whole country is slightly more than that 1,000. And so investment in local infrastructure, it also involves investment in electricity and fiber connectivity, and then digital literacy and civic empowerment. Digital literacy will involve teaching people as well as educating the different people, the masses in terms of the technology that they use and the privacy implications of sharing data within the apps that they use, promoting indigenous technologies and content. If we are less reliant on the US-based technologies or Chinese-based technologies, I guess we can have some form of control. And then also strategic engagement with the different international providers. I think for me, the recommendation for the sovereign, the individual government is I'll echo in the local infrastructure and prioritize local data centers and internet exchange points, enforce and also update legal frameworks. It's crucial to ensure that data protection laws meet international standards. And for civic society in particular, I think there's a space where we can. That's one of the key things that we can actually start to do. I've noticed the international companies have so much power, and we are seeing that growing. Right now, if Firefox browser has been compelled to issue to have one setting that can actually ensure that all data collecting websites will not collect private data from your browser. It blocks collection of metadata and cookies and etc. and any other data that is normally collected by websites. And this has happened this was done through international through civic society and many other tools that are being developed through civic society and research like this from civic society and academia. So I believe digital sovereignty for Africa must not be mistaken, and I'm winding up for isolationism or technology nationalism. Rather, it's a framework for inclusive development where African countries assert control over their data, digital infrastructure, and whilst also embracing openness, cooperation, and innovation, and in creating a digital ecosystem that is secure, right, respecting, and empowering all its citizens. As the world experiences technological change, Africa's decisions in the coming years will determine whether it becomes a passive subject of global digital governance or an active ethical sovereign actor in shaping it. I think I'll stop here.
Very much. Thank you very much, Christopher. Very interesting questions about data sovereignty. And yes, I think that I know there are some comments in the chat by Andrew, Dr. Andrew, and the rest. The issues about sovereignty in terms of data storage and data protection, very important points. I think just one for me, this can be a point for reflection. Remember, one of the countries that we're engaging with when we're talking about data breaches and data protection. One is that, does sovereignty necessarily mean in the boundaries of a country? I think the argument was that our laws only allow us to keep data within the boundaries of a country, and we can't keep them out of the country. So we need to amend that. But if we're having the servers here and the data are in Africa, but run by different individuals who are not African, can one still talk about sovereignty? That's a very interesting point. The other one is having offsite storage for data in, for example, embassies of African countries. And then I think you mentioned the point of, yes, offsite storage of data, but then when there is data breaches, which law applies? That would be interesting. And I think the argument there was that, can an embassy of South Africa in Denmark, or an embassy of Malawi or whatever in another country, what do we deem it as? And the data there, which law should regulate the data in those embassies? And at the same time, if we have an offsite server in those embassies, what law should suffice? Those are very interesting conversations that came on during that discussion that I thought maybe, Christopher, you can maybe tease around in your paper, but thank you very much. Dr. Andrews, do you want to supplement on your point?
Yes, please. So firstly, great presentation on a super important topic. So thank you very much for that. Really appreciate the good topic and the discussion. The concern is twofold, and it's a supplement to what you've been saying. I think the data center example, for example, there's two levels. One is, so for example, I live in Cape Town, and there's a lot of Amazon Web Servers, 2 kilometers from my house, but they're controlled by Amazon. So yes, South African law could say what should happen in those data centers, but ultimately quite hard to enforce without a lot of technical capacity. The other one is actually a different point, which is, how can we accomplish digital sovereignty without controlling the software? It's one thing to run a data center, it's another to not control the software. So we know, for example, and Microsoft admitted that where they find what are called zero-day exploits in their software, that they give those to the National Signals Administration. They give those to the NSA before they make them public. So in other words, they enable their intelligence agencies to spy on every other government running Microsoft. So how can Africa accomplish digital sovereignty for as long as we're running proprietary software from outside the continent? The answer seems to be open source. So I think it would be worthwhile addressing. I mean, you don't have to do it now if there's not something you've thought about, but how open source could help African governments in particular have control over the technology they're running, because right now they don't. And also how perhaps together, because very few African countries have the budget to support development of whether it's proprietary or open source on its own, together African countries could build an open source kind of stack, just like the Europeans are building the European stack to accomplish greater digital sovereignty. Thank you. But thanks once again for a really great presentation.
Great, thank you, Dr. Andrew Rents. Any other comments before? I'll definitely make Hilingwe a default last commenter. So anyone has a comment before I can ask Hilingwe to come in? Please, if you have a comment for Christopher, please. Okay, maybe Christopher, you can address those as we see if there are any other. But thanks for the very interesting discussion, because I know that in most of these things, Africans, we run to the default, our sovereignty, our sovereignty. So when it comes to data, I don't know how good we are there, but that's a very good paper. Christopher, over to you. You can answer those as we see if there are any. Yeah.
I think, yes, thank you. I agree. It's a very important point. I think I should include about open source, because all of these closed source systems would have some form of backdoors that are required for surveillance purposes. So just to explain for the non-technical users, open source means the code is available for audit, and anyone can see whether there are backdoors or whether there's any other data transmissions or any other things that are happening within the software that are not publicized, or the software is doing what it's supposed to do. So using open source would be very good. And most open source comes for free because it's developed by a community which contributes to the technology. And so it also comes in cheaper to have that sort of infrastructure. But then, of course, we still need good power supply, good reliable internet connectivity as well, and to make sure that everything else runs well, and we are able to replace the traditional cloud services of Amazon, Google, and Microsoft.
Right. Thank you very much, Hilingwe.
Thank you so much. Thank you so much, Chris, for the presentation. You know, when somebody prefixes their presentation with that they come with 20 years of experience, hey. But I'm sure as Chris was presenting, you could really tell that there is a wealth of experience that he has around the areas, and you know, especially when it gets into the technical aspects. So just a few issues, Chris. So I know other colleagues have not read your the draft paper so far. So, but I think in terms of the definition and scope of digital sovereignty itself in the PEP, when you are presenting, it doesn't, that gap doesn't really come out. But when you read the actual paper, I think what I felt was that you need to bring about the definition, like clarifying exactly what digital sovereignty entails very early on in the paper. So this helps really in framing the entire discussion. It does come out, but I think there could be more clarity. And then also the theme around legal harmonization, it's really a key theme in your paper. But you know, when you are reading it, one doesn't really envision or doesn't really see how you are envisioning it. I think probably a more in-depth explanation of how that looks like practically. I think that would be great. And then in terms of I know you're a very technical person. You're a very technical person, so I think about the reader who is not as technical as you are in some of the terms, in terms of the terms that you use. You know, some of them you know, internet exchange points, you know, cloud platforms, what are they called? Some of them fiber optic backhaul. These are very simple terms from where you sit, but if you think of other readers who might not be as technical as you are, those are terms that might actually require you to provide, I mean, some explanations so that, you know, all readers can follow the discussion. And then also, I don't know if I remember correctly, but some of the terms, you know, such as, you know, that were being used interchangeably, I'll go back to the paper and email that to you. But there were some terms that I felt like there was some inconsistency where, you know, you're using them interchangeably. The issue of state and non-state actors as well. I think it's an issue that comes out in your paper. But I felt like there isn't much clear delineation, you know, of especially when it comes to some of the relationships and potential conflicts that arise and some cooperation mechanisms. Maybe we need to go back and look at some of how some of these relationships are presented and kind of clean it up, and so that there is some of the issues are not blurry. And then also on the case studies, you know, there's, you know, good reference of, you know, countries such as Nigeria, Kenya, South Africa. These are mentioned, but I think also there has to be some, you know, linking it to the broader, weaving it into the broader discussion so that there's that golden thread, that logical flow. I like that you end with proposing a set of recommendations. And in your set of recommendations there, I think also you need to go back to it and check that there is a clear link between the, you know, there's the challenges section and gaps that you discussed prior to the recommendations section. So I think there has to be a clear link between what is being proposed and the gaps and challenges that have been identified so that there's a logical flow and it's easy to understand where the recommendation is coming from or what informs the recommendations. Yeah, I think those are some of the few issues that I have.
Thank you very much, Lingwe. And Christoph, do you have, most of them have been comments. Do you have any quick response before we jump to Dr. Aaron?
Yeah, thank you for that, Lingwe. I've noted the issues, but I hope they can be emailed as well. I hope I've captured all of them well. But it would be good if you had them written down somewhere so that I can really be able to apply some of the changes.
All right, thank you very much. Thank you, Christopher, for those interesting conversations. I see hand claps going up for you. We never think about sovereignty. We only think about sovereignty in terms of our borders and monies and the rest, but yet data is very key, especially on that. So now let me ask Dr. Salau to come in and talk to us about the issue China. Everyone is talking about China and technology and privacy. So, Doctor, you're welcome. I'm going to to share your slides here so that you can just do the audio and maybe video your side. Thank you.
Yes, thank you so much, Michael. So my name is Aaron Salau. And when I'm going to present on the creeping influence of China's cybersecurity and digital surveillance norms in Africa. This, when we talk about the influence of China, this we all know, everybody is talking about China, Chinese technologies, and so on and so forth. So, but now within the context of digital transformation in Africa, you can move on to the next slide. We can look at, from the perspective of internet growth in Africa. Statistics tell us that for quite some time now, internet penetration in Africa has more than doubled the global average. People now have more access to digital phones, internet, social media, internet-enabled social media, and the rest. And of course, the African digital economy is growing in leaps and bounds. Now that African countries have now appreciate the enormity of the digital economy and the potentials. And so all the African nations, many of them are now putting laws in place, regulatory institutions, to be able to tap into that potential. Now, of course, there are African strategies that have been also at the regional level, the AU level, that have been, articulated, for Africa perspective, from African perspective, but this digital transformation in Africa, or digital leap, is not value neutral in terms of if you talk about the infrastructure. The infrastructure, though brings about a lot of speedy interconnectivity, the ease of business, and e-commerce. But it's not just about those things, but who owns those networks? We talk in terms of the power that it gives, in terms of how it shapes the norms, the design. So technology itself is not value neutral. So that's one of the challenges. So you have competing claims, geopolitical claims or competition over technological standards and infrastructure. And you discover, of course, as we all know, that Chinese companies are now having upper hand. African nations are tilting towards Chinese technology. So this leads to inroads, acceptance of normative and governance frameworks that reflect China's cybersecurity and digital sovereignty approaches. The last presenter talked about digital cyber sovereignty, So, but now China has its own notion, its own philosophy of what is cyber sovereignty. We'll come to that later on. So, China-Africa cooperation in terms of digital engagement is in terms of infrastructure that's coming, in terms of software development, deployment, in terms of capacity, training, and all that. And so these are avenues for China's and Chinese norms and frameworks. Despite the fact that we hardly have laws, wholesale, any kind of wholesale importation, but you have those norms playing key roles in and the governance structures that are now in place in Africa in terms of the digital content that we have access to. And so would this present a profound challenge to African digital constitutionalism. So next slide. Let's go to the next slide. So that brings up the question. I haven't talked about the huge dependency on Chinese technologies. Like I said, these are not value free. These technologies are not value free. So people have talked about, a lot of writers have talked about what does China stand to gain from this heavy investment in Africa, in the African digital economies. So some have talked about a kind of neocolonialism, which is the many writers talking about pure digital colonialism, like something related to the X2 land grabbing and all the rest, like the transatlantic kind of colonialism. So they have made a comparison. Or some have said China is trying to expand, that this is part of the geopolitical war with the Europe and the Americas and America. So, but on my own part, I feel we should look deeply into other areas. Africa, we will not say that Africa is a passive consumer of Chinese technology. Relationship is a bit complex. Talking about, we can talk about mechanisms of how these digital norms are brought into Africa, and whether African countries are presenting any kind of independent, whether we are independent receivers.
Doctor, we lost you. Looks like we lost Dr. Salau. Let's give him a minute and see if he'll return.
Can you hear me now? Hello?
Yes, now you're back. Yes.
Oh, okay. Okay. All right. So basically, this paper makes 3 contributions. Basically, we address the gaps in literature through, I conceptualize African digital constitutionalism. Then I look at the basic assumptions underlying African and Chinese data protection frameworks. This is a comparison. And then also I look at the African, a few African states, the data norms they have subscribed to, and then what are the implications for data protection, when there are competing norms GDPR style Chinese norms and all the rest. So then I make some recommendations. So the next slide talks about the digital constitutionalism, and I look at it as a kind of constitutional approach to digital. How does the constitution govern? How do we adapt constitutional principles to emergence of technology? So we talk about the kind of rule of law, digital constitutionalism. So that's the basic definition I want to give to it. And then I want to look at the African digital constitutionalism that is emerging in terms of the constitutional amendment recognizing digital rights. We now have data protection laws, both at the state level and the regional levels. The Malabo Convention is there. And then the implementation, the political will, the technical architecture within which these laws operate. So these are part of the framework for African digital constitutionalism. But beyond that, I also want to say that African digital constitutionalism can be remodeled towards a kind of cyber sovereignty that we're all talking about, in terms of articulating principles that reflect African values, contexts, and aspirations. While we can accept technology from other regions, but our values should not be thrown into the dustbin. And so, how does Africa negotiate? How do those values that are dear to Africa, how do we incorporate them into the emerging technological frameworks, the design? So we want to suggest the Ubuntu approach. Many writers have talked about the Ubuntu approach, which is talking about, it's not just about individual rights, but also talking about collective welfare. And so, if we are going to have an Ubuntu approach to African digital constitutionalism, that may help us to fashion out data protection governance that protects individual privacy while also enabling communal benefits inherent in data sharing. Of course, we cannot throw away the values of transparency and accountability, which must also be central to African digital constitutionalism. And it will also involve, apart from legal provisions, there must be institutional frameworks for oversight and redress, etc., etc. So let's go to the next slide because of time, and let me not bore you so much on that. I talk about this in the full paper. So let's go to slide 6. Let's just move on to slide 6 now. Just proceed to, yeah, that's where we are now. So what I've done here is, no, please go back to slide 6, which is a comparative analysis of data protection and cybersecurity frameworks and mechanisms of Chinese digital norm diffusion. Okay, so here I've tried to combine two basic areas of my discussion. The first one is looking at what are the data protection frameworks, comparing Chinese frameworks and African frameworks. And so we look at 3.1. The major African framework is the Malabo Convention, which we all know about, and it's the provisions that deal with e-commerce, deals with personal data protection, and of course, it also deals with cybersecurity. So we just highlight a few of the provisions that talk about protection of personal data. Of course, it embeds the GDPR-styled data processing, the principles of data processing, consent, legitimacy, storage limitation, and so on and so forth. Then it talks about data transfer. Of course, the rules of data cross-border data transfer. Limiting to limiting transfer to regions or countries with comparative protection that we have in the Malabo Convention, just like the GDPR also provides. And so then we talk about the cybersecurity provisions. Maybe you look at the articles 28, 24 to 28 or 29, which talk about cybercrime prevention and the modalities, incident responses, critical infrastructure protection, and the rules that guide all these technology companies. Providers must abide with these rules of cybersecurity governance. Okay, so to ensure that the networks are safe, the data is safe, and so on and so forth. Okay, now the enforcement provisions are actually non-existent because it talks about a monitoring body that is yet to be in existence. Okay, so but when we look at the Chinese now, let's look at the Chinese.
Since we lost Doctor again, we'll give him a minute and see if he returns soon.
Okay, I think I have network issues. I don't know whether you can hear me now.
Yes, now we can.
Okay, so now let me just shorten the discussion. So if you look at this Chinese cybersecurity framework and data protection framework 3.2 on the right side of the screen, you see the three laws I mentioned the three laws that intertwine cybersecurity and data protection in China. Now, there are basic contrasts with the African provisions. Basically, the laws mandate data localization. And then this data localization is controlled, it centers on China's cybersecurity framework, which makes data control by the government a central aspect of governance. It makes it a central aspect of development. Government has almost absolute control over personal data. And so access is given for reasons of national security, public interest. Then you have classification of data for security reasons. So all these provisions, then if there's going to be cross-border transfer, there are very stringent rules that guide this. So basically in China, the framework that we have in China is about government control. And then when government collects data, you don't have judicial oversight. All the laws do not allow judicial oversight to government interests when government interests are at stake in data. And of course, the laws allow government to have access, backdoor access to encrypted data. So in contrast to the liberal-styled provisions that we have in the Malabo Convention, and of course now in the numerous African data protection frameworks, like we have the Kenya, we have South Africa, we have Zimbabwe. So I move on to 3.3, now talking about African domestic frameworks. Many of these frameworks virtually are GDPR styled. We have variations. Some are more stringent than others in terms of the security, how they center security, national security, public security, etc., etc. Now, let's talk about now you have several ways in which when African states adopt Chinese technology, I want to talk about mechanisms of Chinese digital norm diffusion. Now, on the left side, the lower part of the left side of the screen, when African states adopt this, when they import technology, and you will find the norm diffusion in three major ways. You have infrastructure dependency. This infrastructure dependency also creates a kind of lock-in that when you adopt technology wholesale and the technology becomes entrenched, and of course people now get used to it, it's a lot of investment, and you need constant monitoring. You need to engage in after sales service, and so on and so forth. Now, to now begin to look for alternative, it's very, very costly. Secondly, you have capacity building. Chinese companies engage in capacity building, and when you look at some of the programs, you find them in the universities. You find them in when the country engages with Chinese companies, they also do training. You discover that the training emphasize on China's norms, basically. And so this is a way of norm diffusion. And these norms are take part in this training. And there's also, you have international coordination. African countries, or the AU as a whole, has been tilting towards China's position in terms of digital policy. We have four Okay, all right. I think I lost the signal. Wow, serious.
Yes, Doc. Maybe you should be winding up as well.
Yeah, I lost signal. So I'm back now. Let me just round up because this signal thing is really problematic. Okay, so now before I leave this section, talking about the mechanisms of Chinese digital norm diffusion, the first one talks about infrastructure dependency. Now, you discover that the Chinese companies are virtually constructed the digital infrastructure that African countries depend on. And most of these things come through soft loans from Chinese banks, and so on and so forth. And so there's a kind of tie, to this. And of course, it comes to conditionalities. Now, so that is that. Let's talk about real case studies of Chinese digital norms in practice. This is in the left side of the screen, where we have 4.4 case study analysis. So I talk about Ethiopia, surveillance. You have ZTE Telecoms that has installed surveillance equipment. In Kenya, you have Huawei Smart City that has Huawei that has installed surveillance cameras for security. Then in Zimbabwe, you have facial recognition systems. Also, these are security systems that have been installed. And what you discover is that most of these security systems actually predates the data protection frameworks that you have in these countries. Then secondly, you discover that even though many of the laws provide for judicial oversight, but we know this is easier said than done. Because this surveillance equipment, work in real time, and they are so pervasive, they collect people's data that even the courts don't have the capacity to address many of the challenges that emerge from the misuse, abuse that are inherent in this security architecture. So this is a picture of diffusion of norms, engagements with China, and then the challenges, even despite the fact that you have laws that are in place. So let's move to the next slide, which just try to give an overview of some of these challenges. So we look at the discussion slide. I mentioned we have extensive surveillance practices despite data protection legal frameworks that are in place. Then, of course, there are insufficient institutional and regulatory capacity, which I've also talked about. Insufficient political will to constrain security agencies. Of course, when these technologies become pervasive, of course, the security minded section of the country become sensitive. Any attempt to withdraw, some of the operations concerning these technologies, they always resist it. Okay, so we have Chinese surveillance systems with assumption that data is central to governance, and governments must have access to comprehensive data. So these are technologies that we import come with this the design come with these basic assumptions. We need to look at this and look for what do we do about these issues. Chinese frameworks treat data as strategic state asset and comprehensive surveillance as compatible with development. So I just moved to the conclusion and recommendations, and now to say the second to the last slide or thereabouts, to say the deepening influence of Chinese governance norms across Africa presents both opportunities and acute challenges for the continent's digital future. For African states to engage with China, this calls for African states to engage with China such that Africa benefits from Chinese technological cooperation while maintaining commitment to digital self-determination. So this is the crux of the matter. The capacity for African countries, the political will to engage. So that is part of the cyber sovereignty. My own way of looking at cyber sovereignty. We talk about the infrastructure, we talk about the software, but this is also very key: the engagement, the modalities for the engagement. So I recommend African nations must confront a consequential choice about the normative foundations of its digital future, of their digital, should be their digital futures. Rather than accept a binary between China and Western liberal models, they must aim for development of authentic African digital constitutionalism grounded in African values. African governments must establish comprehensive digital governance frameworks, balancing security security with privacy, etc., etc. African government must build institutional capacity for oversight and enforcement. The data protection authorities must be given the leeway, the free hand, the technical expertise, and the resources to audit sophisticated systems. Ditto with the courts. Then the Malabo Convention, of course, just a few countries have ratified it. So, which shows the basic challenge for these Chinese inroads, the inroads of Chinese norms and cybersecurity governance frameworks into Africa. And so we need to expedite Malabo Convention implementation, and of course there needs to be a monitoring framework for compliance by states. So the next slide, just to thank you for listening. Thank you so much.
All right. Thank you, Doc, for that discussion about China and our data issues. So I want to ask that I know our time is moving very fast, but we have 2 more to go. Yeah, those are you're getting digital claps there, Doctor. Thank you. So anyone with some comments before I ask my default commentator, Hellingway. Any comments on this? Okay.
Michael, I'm hoping that Chris can at least have some comment of some sort.
Yes, because they're almost
He's an expert in this area.
Okay. Chris, I hope you're still there. Any comments on Doctor's discussion about China, the creeping influence of China's cybersecurity? Yeah, maybe Doctor, as that happens, maybe in your paper, because you're talking about the creeping influence, is Africa, because normally Africa is is doing what we call catch up on issues of digital, but also we are a consumer. In your paper, do we see a trend towards us safeguarding ourselves against surveillance, but at the same time, taking in these technologies? How would we draw the balance? Because we don't manufacture a lot of these here, especially the softwares, I think like Chris said. How do we draw the balance between needing the software, needing all these products from China and services in terms of the digital rights and privacy, but at the same time, do we have enough shield as Africa against the surveillance that these will come up with? Thank you. I think you can answer that. Then I see Dr. Mugambi, and then we will take it from there.
Okay, thank you so much. Sorry for taking so much time presenting. Yeah, so I think Africa can actually leverage on so many things. Even though it's like Africa almost looks like a basket case, in terms of consuming, being a consumer. But we have the numbers. Africa is an emerging market, and you discover that some of these technologies that come from China, some actually are being launched in Africa, maybe for the first time. Some of these technologies also have been, like AI, we talk about AI-based facial recognition systems that you have in Zimbabwe. Some of these technologies have been, they've utilized data, they are utilizing data in Africa maybe for the first time when they were deployed. And so you have issues with this AI trained with different kind of data from different geopolitical setting now being brought into Africa. And so that's a basic challenge. And so Africa now becomes like a testing ground. And then, of course, they also use technologies to collect the data, because it's about control. Who has the controlling power over these technologies? So now, but because we have the numbers, Africa is yet an untapped market, basically, relatively to other regions. And so this could be like a leverage, could leverage on this market power to negotiate, design, design of infrastructure. And because that is the way I would look at our cyber security sovereignty, cyber sovereignty. We may not have the technology, but we have the market. And so we could look at this. But of course, the political will has to be summoned. The Chinese companies that come to Africa, of course, there's heavy dependence on Chinese loans to facilitate this infrastructural development. And so that's also another aspect which we can leverage. China is looking for outlets, for its technological companies, and trying to compete globally, with the ones that come from the Western world. And so Africa is like a beautiful bride, if I can use that euphemism. Africa stands like a beautiful bride. Africa has to be courted, to allow these technologies to come in. And so we have that power if the African leaders will just open their eyes to see, those potentials that can be leveraged. But of course, it's not just about talking, but it's just also about putting in place mechanisms. We talk about, there was a time there was a scandal that the Chinese companies actually collecting data from the African Union. So which means there is surveillance going on. The technologies bring capacities for surveillance. But of course, the challenge also is that African leaders, there's a meeting of minds. It's not just about China's geopolitical interests now playing out, but somehow African leaders had idem with the surveillance capacities, because it gives them enormous powers to actually monitor political ongoings. They monitor electoral issues, voting patterns, and mobilizations, political mobilizations, and all that, because of these powerful tools that they have. So there's convergence between China's interest and African leaders' interest in that wise. But of course, African nations will lose out if it's all about self-interest. So we can, and African companies are also not doing badly. In the private sector, we have a lot of payment platforms that have been developed. Unicorn, they call them unicorn, maybe flagship companies or whatever. Unicorn startups that have actually emerged in the banking sector in Africa, that are Africa-based. And so we have the manpower can actually be developed to greater extent. So Africa so we have the manpower, we have the people, but it's just deploying the right programs, the right investment in the right places that Africa too can have a share and can be a partner, with China, instead of just playing second fiddle in this technological engagement. So I think I can stop there for now.
Yes, thank you very much, Doctor. Let me now ask Dr. Mugambi to give his comments, and then Christopher will come in, and then lastly, Hilingwe, and then we can move on. Thank you.
Okay, thank you. Very, very, very great insights. So I was just thinking aloud. So when you're talking about influence, one of the things that we lawyers, myself included, we forget is the diplomatic and the geopolitical angle to all this. Because the influence, like, for example, let me talk about Kenya, how these technologies come in, is that they're usually hidden in government-to-government trade agreements. So you find if you're digitizing in government, the executive will go to China, or China will come, and they'll have a handshake and provide these technologies. What that does, it's that it waters down everything we talk about, like regulation, because it's really hidden. It's really hidden within very fine print of trade agreement. So that's one of the ways that this influence comes. Secondly, there's this growing influence of roles within big tech, which we call government affairs experts or government affairs professionals. And these are people within big technology or basically large private sector who have interaction with government or public sector officials to deal with issues of something that we call regulatory entrepreneurship, where you design your product relating to how the regulation is done. And that, of course, becomes a very big challenge. And then thirdly, practically, I'm talking about like the clients that I represent. It's cheaper to buy Chinese technology and software and hardware. It doesn't matter whether there's surveillance or not, but simple, an SME that needs a product, whether it's hardware and software, they'll basically look at their cash flow and say, okay, where can we find these servers, these computers within an affordable range? And they'll go to the one that is quite affordable. So there's also that in terms of the practicality. Then also it's the fact that also the Western, whether you're talking about tech that is from Israel, tech that is from the EU, tech that is from the US or wherever, that their role in surveillance actually has been longer than what the Chinese. It's just that the Chinese have started doing this a bit more recently, but their surveillance machinery has been entrenched longer and more deeply than the Chinese. It's just that now the Chinese are offering a cheaper version of the Microsofts, of the Oracle, etc. So I think those are some of the things that mostly you find that it's journalists who write and talk about these things, but I don't know how, as lawyers, I'm assuming that putting myself, how we can bring this argument within the regulatory angle. Thank you.
Okay. Yeah, thank you. I think the challenge is also about governance. When, for instance, in Nigeria, when there were civil society agitations. Actually, there were demonstrations, some time ago, and social media. One particular social media company was actually deeply involved in helping publicizing as the protests were going on real time, and also trying to also mobilize some kind of funding digitally for the protest movement. That was the hashtag. I've forgotten now about this police riots. About police practices. NSAS. This NSAS protest. So the Nigerian government woke up and now tried to take off that social media off the air. And of course, there were negotiations. It was banned from Nigeria, and of course, they had to negotiate. The management had to negotiate with the Nigerian government on certain terms, and that happened in the background. And up to now, nobody really knows the actual terms of the negotiation. But of course, it came out that one of the conditions was that the company must have physical presence in Nigeria. So, which means it found a way to make sure it becomes a tax citizen in Nigeria. And also, governments also has some leeway, maybe as they think, to monitor those who are behind, the company, to have access to the operators and all that. So this is just an example. That leverage has always been there, but African nations hardly put this leverage into effect, except for selfish reasons. So that's just a basic example of how these things can work for us. So in terms of regulation, we said data is oil, and of course there are the great monumental potentials for us to benefit. Talking about our numbers, I talk about our numbers, talk about the market, and so there's people are yearning for access to these technologies, and it makes life easier. So we can look around this. If African countries will not just focus on control in terms of controlling the people, but focus more on benefits, that the collective benefits, maybe things can be better. I think I've tried to answer the question.
All right, thank you, Doc. Christopher?
Yeah, I think we've spent a lot of time on this one, and I'm sure Hlengwe will have a lot to say as well. Thank you, Doc, for the insights. I would just a few comments, just maybe a few pointers or some of the things that you can also refer to. I think the facial recognition surveillance system that you were referring to is it was called CloudWalk. That's the one where there was an agreement with Zimbabwean authorities to supply the system for the airports and public places. And in turn, Zimbabwe was going to allow them to collect data that is specific to African or black faces, for lack of a better word, to train their system. So if you Google this, you'll find there's a lot more information about this, even covered by the state media. And then we've had issues to do with a way that are well documented, particularly complaints coming from Europe. And EU is the biggest supplier of Huawei is the biggest supplier of telecoms cell towers, and there were reservations about their 5G cell towers, and some many countries in Europe and including the US were banning them. But we also know about how these companies collaborate with African governments, like in Uganda when Bobi Wine was arrested. Huawei employees allegedly supplied information to the authorities in Uganda as well. And then so most of these come through the Belt and Road Initiative and other infrastructure deals. And their loan is kind of like free infrastructure that you pay over time, and so it's attractive to Africa. And so Africa is on this debt trip, but we are not sure how much data is being collected, or what and the other extra gains apart from repayment of loans that the Chinese government would also get. And also, you mentioned the AU data siphoning incident. I think concerns are also around the other government related or national infrastructure that is donated to different governments, like in Zimbabwe, the national parliament, the military building, the airports, many airports in Africa, actually. And so this incident in AU also raises fears that we have seen that there might be other cases to do with that. I just thought I would mention that. I don't know if Lengiwe will also mention the research that we also did that could feed into that. It raises a lot of data that you can also add into to your research. But thanks for that, very insightful. Over to you, Lengiwe.
Thanks, Chris. So Chris is referring to, don't know whether it can be seen with what I've done in my background. We did something on similar. I think I can share with you this initiative, what came out of this initiative. I think it would be very useful. It was looking at Mozambique, Uganda, Zimbabwe, and Tanzania. Very useful case studies, and they touch on some of the issues. So just on the I'm mindful of the time, so I'll be very brief. On the, I know the paper is on China, but I wonder, this is not a recommendation, but just something to think about. I wonder whether it will be useful to somehow take into account other international influences on on Africa's digital governance, whether that will kind of that comparative analysis or framing will situate China's influence in a broader geopolitical digital landscape. So when I was thinking about it, I was wondering whether it could actually inform your framing, or maybe it can become another whole separate paper, or there could be a strategic way of mentioning it, something to think about. And then you mentioned also training programs. I was wondering whether you are saying that this is a form of normative, transfer of Chinese governance models through these capacity building programs. I think you can strengthen those parts and probably provide a more detailed analysis around the contribution of those, training programs. We also in this work mentioned the training programs as well. And then also the role of civil society organizations. I felt like their agency, strategies and impact in shaping, governance doesn't really come out very well. Maybe if you can, look into that. The terms also, you throwing in terms, the digital constitutionalism, cyber sovereignty, digital colonialism. Please do define them so that it's very clear what you mean by those terms. And then also, I think this work can benefit also from some kind of a theoretical grounding. The concepts that we have been engaging on. I don't know whether you want to ground this on digital sovereignty or technological dependency or constitutionalism, but some kind of theoretical grounding, I think, will be it can kind of streamline your work. Thank you so much.
Thank you. Sorry, can you repeat the last statement? Sorry, the line was breaking.
Okay, so
The la-
I was saying that to delineate your research, it could help if you can probably be clear on the or more clearer on the theoretical grounding, whether this is based on digital sovereignty or whether technological dependency or constitutionalism. What is your theoretical framing? I think that also is going to help you in shaping your argument or the
all right.
focus of the paper. Yeah.
Yeah, thanks. Yeah, yeah, great. Yeah, thanks so much. Thanks, I appreciate. Just like the other presenter said, maybe I don't know if I could have this in like comments,
Yes, Doc.
written comment.
We
I don't
will.
know. Yes.
Yes, Doc. We'll also share the recording of this to everyone. So, apart from the other comments that will come, so yeah, if there are any specific ones that you could respond to, you can do that in a minute and close. But if most of them have been comments, but you can close in a minute and then we move on to the second one. But we'll also share the recording with all of you. Thanks.
Thank you.
Yes, Doctor, you can go ahead in 1 minute and you close your site.
Okay.
Okay, we've lost you, but I was just giving a minute to wrap up. But thank you so much for that conversation on China. And if you check in the chat, colleagues, there have been a number of links shared that you can read on some work that has been done on this issue. All right, so I now want to go to Mr. Mbogeni on issue Chinese safe cities in Africa. It seems today it's about China. So Mr. Mbogeni is going to discuss Chinese safe cities in Africa. So over to you in probably 10 to 15 minutes. And then colleagues, just bear with us. I know we had agreed that we'll end by 1 p.m. South African time. But you also understand that the discussions are very healthy. But we just have 2 more presentations, and then we'll call it a day. So just bear with us. I hope Mr. Mbogeni is on the call.
Yes, good afternoon, sir.
Very good.
Good afternoon, sir. And
yes, good afternoon.
Good afternoon, everyone. I'm going to be short, and the conversation that you had towards the end was unpacking most of the things that I have for my research. I don't know what's going on with my camera, so that maybe you can see my face, but it's refusing to show. Can I go straight to the presentation?
Yes, please.
Okay. I don't know what's really going on with
It could be your earlier settings where probably you didn't allow your computer to use your camera.
Okay, but what about the screen? Are you able to see my screen?
Yes, so if you could just play it in the slideshow, then yeah, to be visible. Very good. We can see it.
Okay. Thank you so much for the opportunity to present this work here. My presentation, the title of my presentation and my book chapter is in a form of a question. Which safety is it in the Chinese safe cities? This is how my presentation is going to proceed. Okay. My presentation is going to process the first point. I'm going to talk about the point of entrance, how I interrogated the issue of answering the question of whose safety is it in the Chinese safe cities. And then I will pose the key research questions, the methodology, how I arrived to the conclusions or to the findings that I've had, and then I will also bring the main arguments of the paper, which is sort of the findings, and also discuss those findings, and I will bring the conclusion. The point of entrance for understanding the Chinese safe cities and questioning whose safety is it is the issue that was raised by the director of public affairs for Hawaii, Southern Africa, when he was asked about the safeguards for protecting human rights. The response was that Hawaii develops technology, not public policy. The development of technology is for Hawaii, and for public policy is for policymakers and legislators. From this response, what I got was that China positions itself as a vendor, just as a technology provider. And the question that maybe we may have again is, what is the responsibility of a vendor? Again, the second point, or is still on that point, that China is a vendor, I would like to bring in the issue that Adam ignores the fact that the Chinese technology is made to control over 1.5 billion people that live in China. That is very important. And also, that means it is made with security, being cautious of security issues that are in China. Then the second point raises the question around issues of African agency, policymakers' agency in protecting their citizens. Which brings in the other issue that African leaders are acquiring the Chinese digital technologies and the Chinese safe cities and the associated technologies to protect their own citizens. But again, the issues around the making of and the designing of the Chinese technologies revolves around regime security, revolves around protecting the Chinese Communist Party. And if you do a lot of reading, you see some official documents from think tanks in China stating that if the regime cannot develop competent technologies, it will not make it in the long run. So to add on to that, as you see from my slides, is that national security and technology are often viewed as inseparable, and the distinction between national security and the security of the ruling party are often blurred. And I also highlighted that the Chinese safe city technologies are exported to countries that Freedom House deems partly free or not free. This is very important as the point of entrance to the book chapter in trying to ask whose safety is it? But again, I also say that there are legitimate security challenges that justify security upgrades. But let me also hasten to say that there is a growing literature that really says we cannot rely on technology to solve our insecurity challenges. We need to find solutions. What are the problems that are really forcing or really leading to the rise in crime, rise in banditry, in violent crimes, and really technology cannot be an answer to that. Then what is the key question to that I'm posing is that for whose safety are these technologies procured? From the first slide, I try to negotiate and bring in issues around the relationship between the Chinese safeties and associated technologies and the regime security. But again, I bring in the other issue of the legitimate insecurity or security concerns. This question is a pointed challenge to the chapter's central investigation. What are the implications of Chinese safe cities initiatives in Africa, focusing on their impact on data protection, privacy, and democratic governance? To answer this question, I reviewed reports by reliable organizations that have been tracing Chinese lending to African countries. I think there is a presenter that talked about, I think the previous presenter highlighted that, and even Christopher highlighted the issues around locating the technologies within a BRI, in which one of its components is about the digital. There's a digital component under the BRI. So I reviewed the reports by the organizations such as Unwanted Witness, Chatham House, Center for Global Development, the China Global South Project, amongst others. And also the study benefited much from the Public Policy and Research Institute of Zimbabwe's China in Africa program, webinars, seminars, where leading Africa-China scholars and experts have made presentations. I also conducted key informant interviews from the civil society. We have offered varying perspectives concerning this issue and investigation. Then what are the main arguments of the chapter? I would like to say that the chapter is situated within the authoritarian diffusion theory. In that case, I found that the adoption of the Chinese safe city technology by African states, specifically the chapter looks at Uganda, Kenya, and Zimbabwe, is a strategic form of authoritarian diffusion, as the theory poses that authoritarian regimes actively adopt surveillance strategies and worst practices from successful like-minded regimes like China, and China acting as a key source of diffusing digital authoritarianism. The model is essentially a political and an ideological transfer, not a commercial transaction. I think this is a key finding that I found. And if you look at the adoption of the Chinese safe cities in Uganda, in Zimbabwe, and in China, and the associated technologies, they have been vastly associated with addressing specifically targeted at opposition activists and people that appear to be a threat to the regime, whereas the Kenyan one offers an interesting perspective around the issues of crime. And if you look at Kenya, it faced some problems around there was an insecurity problem where a lot of people were killed, and there was therefore a need for the police, for the security apparatus to be equipped with the contemporary surveillance technologies. But if you look at the closer reading around that again, there is no relationship. Even if the Huawei and the government releases reports that crime has reduced since the adoption of these associated technologies and others. But other scholars, they highlight that it's very difficult to suggest that when the surveillance technologies were adopted, crime has really gone down. Others really say it's very difficult. And if you look at the case of Uganda, you find out that the Huawei technology that is used by the police there was used to track down the opposition activists or opposition member of parliament, or which is known as Bobby Wine, and they used experts from China to come and decode the messages that he was sending, and they diffused the events that he had meant to have. So the second point is that that I have as the main argument is that there is weak data protection and privacy infringement. The widespread adoption of these technologies, safe cities and associated technologies, is occurring within weak legislative and institutional frameworks for data protection. I think, is it yesterday? There is a presentation that was made yesterday. I think we are still a long way as a continent and as African countries, particularly Zimbabwe, Kenya, and Uganda, in terms of developing the legislations that really safeguard people's privacies and others. The legal ambiguity is often exploited or even deliberate part of the diffusion process, making it easier for authorities to violate citizens' rights and making it difficult for citizens to challenge these violations. The new laws sometimes legitimize mass surveillance instead of checks and balances. I think this has been the laws, and a lot has been presented by, I think Christopher said a lot around this. So the reliance on foreign suppliers like Huawei introduces a profound external security risk and diminishes national sovereignty as sensitive citizen data is exposed to potential misuse, theft, and transfer to foreign states. In this case, is China. The relationship can create a dependency on the supplier or maintenance and support. I think this has been one of the findings that I found, that most of the equipment is written in Chinese and will require people from China to come and interpret, even if we have interpreters that can interpret the Chinese. But in terms of the actual maintenance, the Chinese techno people will need to come and to the servicing of the equipment. This has been the case in Uganda, and even if it's outside the scope of this chapter, if you look at Lesotho, the Chinese are coming to service the equipment in the provided parliament and others. So I saw that there is an illusion of safety and external security risk. The implementation of the Chinese safe city model leads to the tightening of civil liberties, the closure of vital democratic space. And this is very important, particularly in countries where the civic space is closed. Usually people have found solace in digital activism and digital in the digital space to express their views. And if you see how the Chinese model of digital surveillance and others, it actually makes it difficult for the people to express their views within the civic space. There is an erosion of civil liberties and democratic space. This one is also very important, particularly when you look at the facial recognition technologies that have been acquired by these governments, and you look at the laws that also deal with civil disobedience, maybe in courts. It makes it really difficult that there is an erosion of civil liberties and democratic space, that you won't be able to go to outside to express your views. If you go there, the facial recognition technologies will capture a face, and if your face is captured, is linked to your registrar general, and it's actually easier for the security people to come and get you. So this is the chilling effect that these technologies they have. So some of the reading will show you that from if you look at the world chapter, you'll see that there's really these technologies, they link the whole machinery, the whole government system, that if you are seen outside, you are known your address and everything. So the findings across the 3 case studies reveal that the Chinese safe cities model, facilitated by the authoritarian diffusion, primarily serves to enhance regime security than genuine public safety. Technology misuse for political control, despite it being justified as a means to combat crime and terrorism, the safe city systems are systematically repurposed for state control. The technology is implemented within the weak and non-existent or unenforced legal institutional frameworks for data protection. The claimed benefits for crime reduction are difficult to verify and appear to be grossly exaggerated in some cases. What should be done is that there is a need to strengthen legal and data protection frameworks. This is very important. I think for most African states, particularly these 3, there is still a development of these laws, the whole legal and policy and institutional framework. There is a need to establish an independent oversight and accountability, ensure transparency and public participation. I think it's very important, particularly for public participation. There's something that Christopher said when he was responding to the previous presentation, that CloudWalk was learning how to recognize black faces. So the question is, was there any transparency or issues around public participation from the people in whose their data, their data was taken from? So these are the issues that there is a need to ensure transparency and public participation. Then back to the question, and in conclusion, whose safety is it? The evidence suggests that these projects are an example of authoritarian learning, where regimes adopt and adapt surveillance tools to solidify power against political challenges. The safety offered is ultimately an illusion for many citizens. It is a security that protects the state from its people, not the people from harm. Thank you.
Thank you for that discussion. Whose safety is it? Technology made in China, but taken the rest of the world. Can that still work? Interesting conversations. So, colleagues, we're going out of time, but thank you for that. Thank you, Mongeni, for that interesting conversation. I picked a lot of stuff, but I was also wondering, is there technology that China exports and it is for the export only and it's not Chinese like the Chinese would use? Very interesting conversation. So colleagues, anyone's with the conversations? And I see that Uganda was mentioned a lot. Of course, I come from Uganda, and I know that the DPO of Uganda has been on this call since yesterday. Thank you for that. It's good to always have the DPS here. And if you have a comment to that, it will be good to hear from you, Mr. Gilbert, later on. I see Uganda has been mentioned a lot here as well on use of Chinese technology and what that means for us. All right, any comments, please? There could even be to say thank you. The question has been answered or waits to be answered. Any comments? Gilbert, do you have any comment? Okay. All right. Thank you very much, Mogeni. And I don't have much on my side, but I think those are very interesting discussions. I'm hoping that at the end, the question is answered. But again, like I said, mine is whose technology is it? If it comes from China and comes to Uganda, or it comes to whichever country, how do we treat it? Which kind of regime are we able to, like those software issues and the rest, very important questions. Okay, any other comment from anyone? Okay, Lingwe?
Thanks, Michael. I'll be very quick. Some of the issues, Mbongani, thank you so much. I'm going to email. But yes, when my initial thoughts were around the main argument. Maybe I'll go back and look at it again, but my initial thinking was that you were not very explicit upfront in terms of your main argument or the contribution, but I'll go back and confirm this. And then in terms of some of the definitions that you did not define, check there's a lot of concepts that you introduce in the paper without really starting by defining what these concepts mean. Mass surveillance, what exactly is mass surveillance. There is also, I remember, authoritarian diffusion, safe city technologies. Which ones exactly are you referring to as safe city technologies? I think those concepts needs to be defined very, very early on. Also, looking at the case studies, I think the discussion around the case studies could be more clearer in terms of the what those projects seek to achieve. I know you were framing your discussion around a question which seeks to answer, but it doesn't flow very well when you're looking at the way the case studies are presented. So in terms of the description of the projects and some of the official objectives and vis-a-vis what the actual impact is, and then when you look at the question of misuse or political repression, and then now moving into the regulatory and legal context as well, and the implications for and some of the implications. So I think there could be a better flow there in the presentation of the countries, and maybe drawing out some patterns. Yeah, and then in the interest of time, really, I'm going to email some of the things. Thanks.
Thank you, Elingwe, for that. And yes, and for those comments, we'll be able to get most of those later. So now let's have our final discussant, Mr. Abdallah, talking about AI, integrated payment systems and data protection. That's quite interesting. Our money is our money safe. So over to you, Mr. Abdallah, and we hope that we can finish everything by 2:30 South African time. So over to you, Dr. Abdallah.
Okay. Good afternoon, everyone. I hope the slides are visible and everyone can hear me properly.
Yes,
Dr.
we can.
Abdallah. Yes, I'm Dr. Abdallah Mrindoko from Tanzania. I'm working with the Open University of Tanzania as a lecturer in the Faculty of Law. My title is Exploring Interoperability and Data Protection Challenges in Artificial Intelligence Integrated Payment Systems. So that's the area that I'm going to discuss about. To start with, the presentation is split into 4 sections. I'll start with the introduction.
Maybe if you, Doctor, if maybe you can play the slideshow so that, yeah. Perfect.
How about, yes. So I'll go through the 4 sections: introduction, existing problem, findings, and conclusion. I'll try to be punctual in terms of time management. So let me start. What actually motivated me to come up with this particular paper? The motive comes from the Tanzanian journey in the interoperability in terms of digital payments that started in 2014. And actually that is the point, or that the time when the journey in terms of interoperability of payment systems started. But actually in 2014, it was just bilateral agreements among the mobile payment companies or these telecommunication companies. And since it was bilateral agreements among these companies, there were a lot of problems. There were several problems and challenges. And in 2024, the Bank of Tanzania launched the Tanzania Instant Payment System TIPS. And actually this was the great, let me call it, was a point of celebration because there was now a clear system and the protections, and there was a fair system in terms of digital payments interoperability. As you can find out, the system assisted a lot people at the bottom of the pyramid in terms of financial inclusion. And actually through this particular system, people could easily send their money in any company without actually any sort of a problem. That's why I'm saying that with the coming up of that particular system that was introduced by the Bank of Tanzania, the system promoted financial inclusion and created employment opportunities, and that the fact in terms of fintech. And since Tanzania has gone somehow far in terms of mobile money services. So with interoperability of the payment systems, a lot of advantages were actually observed. It promoted financial inclusion, as I've said, and actually through mobile banking or mobile money services, people who could not access bank services obtained actually a clear platform for financial services, sending money, receiving money, and other activities of that sort. And also it supported cross-border payments. People could easily even send money to their colleagues, to their families. And in that case, it strengthened system resilience And also it reduces transaction cost, because at the beginning, the cost for sending money was somehow higher. And with the intervention of the Bank of Tanzania, it reduces transaction cost. And in that case, it means people could easily send money in any company without any sort of a problem. Now, while we were actually celebrating such things, and you can just imagine that it was in 2014, and at that particular time, we had no actually data protection legislation, because the Personal Data Protection Act came into force in 2022. So we were just relying on the Constitution of Tanzania, because it has a provision for the protection of privacy and Article 16. But also in 2015, the Electronic Transaction Act were also created, and it had some provisions with regards to data protection. And also in terms of security and other things of that nature, the Cyber Crimes Act also cemented the issue of consumer rights and consumer protection. But also we had the National Payment Systems Act of 2015 that regulated mobile payment systems. And apart from that, we had also the Fair Competition Act of 2003 that regulated the competition, though it had no proper provision in terms of regulation of electronic issues. So the digital market under the Fair Competition Act was not, and is still not, fairly regulated. But with the Tanzania Instant Payment System, at least in that particular year of 2024, there were some guidelines that were regulating interoperability. And in 2024, in terms of legislative efforts, the government came up with what we call the Tanzania Digital Economy Strategic Framework. And within the framework, there were a lot of issues that the government actually put in place for the sake of, as the mission towards the digital economy. So these were some efforts in terms of legislative developments. But actually, what was so interesting, while we were actually looking at interoperability of payment systems, within it, there was an integration of what we call the current baby at this particular time, the inclusion of artificial intelligence within the payment system. And as a result of that, what were the main problem? And actually, these are the issues that motivated this particular research. There was data interoperability, because you could easily send money from different companies. A person could easily send money from Vodacom to Mix Bayasi, could also access some issues within traditional banks. So the system created or simplified the whole process, but it created what we call data interoperability, which refers to the ability of information generated by one service provider to be transferred, accessed, and utilized by another. So it was a dual issue, that there were some advantages, but also disadvantages in terms of data protection and privacy. So this raises critical privacy implications and highlighted the delicate balance between promoting innovation and protecting individual rights. And these were the issues. How do you balance? And in the era where artificial intelligence is also incorporated in the financial sector. So that's why we are saying that the integration of artificial intelligence into interoperable financial systems magnifies the problem. Now, this is a serious issue that we need to see, and how. Now, from such issues, the findings of the research observed the following, that while there were some efforts in terms of financial transformation, but with interoperability, apart from having some guidelines within TIPS, there was no proper legal framework within the system. So there was a lack of interoperability legal framework that could regulate issues regarding liabilities and who should be liable in terms there is abuse or there is a leakage of data or whatever, which company could be liable. If I'm sending the money from company A to company B, while I'm just have a proper contract with company A, in terms of the money, or if the money is not reaching, what could be the issue? Though there has been some approach of how consumers could be rescued in terms of that, but we are missing a proper legal framework. And since there was some efforts from the Bank of Tanzania through TIPS, but actually TIPS is driven by guidelines and circulars that are issued by the Bank of Tanzania rather than a clear legislation which could provide clear ways or mechanisms of resolving some issues which could happen. And while we are just depending on the circulars and guidelines, what are the limitations? The limitation that was observed is that guidelines are limited in their enforceability. You cannot enforce. Though the Bank of Tanzania is actually standing there to watch what is happening. But in the absence of clear legislation, legal framework, there are a lot of challenges. But we are all aware that the coming of TIPS controlled the issue of Fair Competition Act. And in terms of digital market, we were actually thinking that the Fair Competition Act, which regulates such issues, could have been actually also promoted to address digital issues. But actually, the fair competition is still yesterday, while issues are just going on. And that was actually one of the limitations in terms of enforceability and the control of the digital money interoperability in the country. Now, another challenge that was observed in the research was the regulatory gaps and overlaps. We are all aware that the coming up of the mobile money services is still at the infant stage in terms of legislation. In Tanzania, the coming up of mobile money is still controlled with the two regulators. We have the Bank of Tanzania as the regulator of financial sector, and we have the TCRA as the regulator of telecommunication industry. And within that particular sector, we are just operating under the two models. We have a non-bank-led model, which is very clear in terms of regulation because it's controlled under the TCRA, these are the banks, and under the Banking and Financial Act, it's well addressed in terms of their control mechanism because they are the ones vested with the financial issues. But the sector is also moving under what we call non-bank-led model. And actually, when you conduct a clear research, you will realize that a majority are just falling under the non-bank-led model, where these telecommunication companies have actually full powers. When a person is registering to get a chip of that particular company is also introduced to financial or to mobile money services. And in terms of regulation, it means these companies are just falling under the TCRA. Though the companies that are just doing these financial services, they're just getting the license from the Bank of Tanzania. But in terms of regulation, there's still a problem. And that is a serious issue in terms of redress mechanism under this particular area. So that has been a very serious issue. Another problem that was also observed is in terms of interoperability and third-party rights. What is this? It's very clear that a person is actually subjected or is just introduced into a foreign company that is not or has not entered into a contract with. Earlier I said that in terms of interoperability, it means a person in company A can get access into another company. But in terms of redress mechanism, we are also getting the limitations in terms of third-party rights. Though there has been a judicial movement in this particular area, whenever a person has some interest on whatever has been obtained. But still, the Law of Contract Act is still actually tradition in this particular area, and is also adhering to the very famous case of Tweedle versus Atkinson in terms of third-party rights. So these are the challenges in terms of data rights whenever there is a violation of the privacy, there's a data breach. Those are the issues that the research actually is trying to disclose and actually try to find out what can be done in order to address all these issues in this particular era of artificial intelligence. But also there is a still challenge. As I've said earlier, the issuing or the services of mobile money, mobile banking is actually conducted by the agents in most cases. And in 2017, the government issued what is called the agent banking for banks and financial institutions. So when you read here, you can easily get the picture that we are talking of the agents banking for banks and financial institutions. So it means these companies which are not actually regulated under the Banking and Financial Institutions Act are not falling under the agents banking. And there has been a lot of challenges. And this particular weakness has also been utilized by these companies. When you go through their terms and conditions, you'll find that they are not adhering to what we call a principal-agent relationship. They have tried to evade some liabilities in terms of anything in this particular era. So when you look at all these issues, you can easily find that the consumer protection in terms of data protection, their privacy and other issues are not well captured within the Tanzanian legal framework. And that has been a serious problem. Now, when you go so far with the inclusion now of artificial intelligence within the system, there has been also a lot of problems. There has been a lot of problems in this particular aspect. Most of these, though I have said that the National Digital Framework has tried to mention the inclusion of artificial intelligence for the sake of promoting the economy of the country. But most of these legislation that are just guiding the process are still actually missing the provision or the inclusion of artificial intelligence. And what is the meaning of that? It means issues regarding liability have not been addressed within all these legislations. And that actually is a lacuna that need to be bridged as we are actually within this fourth industrial revolution. Without actually addressing that particular issue, issues of liability and other issues of that nature are still missing within the legal framework. So if that is the case, what is the way forward? The study calls for a comprehensive reform of Tanzania's regulatory architecture. We need to overhaul, we need to enact, it's not the issue of amending the laws. We need to enact two important laws. Firstly, we needed to address the issue of interoperability within the financial sector. I'm sure that interoperability has also gone in the health sector and in other areas. But in the financial sector, we need to come up with a clear legal framework that will address the issue of liability and the protection of data when actually the consumers are actually getting the services of all these companies. It should be very clear. If there is a breach of data, who should be liable? But also we needed to include the issue of artificial intelligence because this has been very sensitive. We are all aware that with the regime of generative artificial intelligence, they have full autonomy. So in case of data breach, it should also be very clear. How are we going to address all these issues? That is a very sensitive issue that needs to be addressed. So what should I say at the end? There is a need of bridging regulatory gaps and aligning with international best practices. I've tried to go to other countries and actually have used, have gone through the GDPA, but also Singapore have tried to come up with issues that with their, what they call this is the financial services of 2019 has tried to bridge at least a gap in terms of protection or issues regarding interoperability of financial services. So that is the approach that should be also taken with Tanzania in addressing some issues as we are going to, as we are within, and not we are going, we are within this digital economy. So that are the issues that could be addressed. After saying that, let me say thank you for listening.
Thank you very much, Abdallah, for that interesting discussion about the payments, integrated payments, and data protection. Very interesting. All right. So again, any comments before I ask Hilingwe? Hilingwe will do two things. She'll give us the comments and then give us the way forward. After all this, what is the way forward for us, the authors, but also the participants? And I am hoping that probably we could have this symposium annually, hopefully. But thank you so much. Anyone that has comments for Dr. Abdallah? If not, you can put them in the chat as well. Doctor will be able to read them because we see that we have overstepped our time, but thank you very much. So if there is no any other comment, I'll ask Lingwe to come in, who will do some comments, but also at the same time, after probably you've addressed them, she will go on to give us the way forward and also close. Thank you.
Thanks, Abdallah. Thanks, Abdallah, for the presentation. I think we got a sense of, you know, some of the issues in as they play out in Tanzania. I always ask when someone is doing something on Tanzania, whether you are looking at the mainland, are you including the island as well?
Probably, actually, I've concentrated in Tanzania mainland because not only legislations are just playing in both parts of the country. So in terms of financial issues, I've just addressed it. Though financial issues is a union matter, but actually I've concentrated in Tanzania mainland.
Yes, my question was around whether is this a union matter or what, and why you specifically chose to focus on the other and not the other. But did you choose Tanzania because you come from Tanzania, or there's a specific reason?
Actually, I've chosen Tanzania because I'm coming from Tanzania, but also there are specific reasons. When you look at the mobile money services, most of the countries that have done very well is Kenya and then Tanzania in East Africa. So that's why I'm saying that there are a lot of issues because the majority have been uplifted from the bottom of the pyramid as a result of such developments. So that has been a reason.
Okay. So just very quickly, like I mentioned with the other papers, there is need to define some terminology there that is used. For instance, when you talk about AI-driven agents, you need to give us that definition. Autonomous systems. I know we have these terms being thrown around these days in digital rights a lot, but I think when it comes to a paper such as this one needs to have these definitions defined or clarified, wherever probably there's a bit of some jargon with it that is specific to the Tanzanian context. Also, just remember that you have readers that are beyond Tanzania who are not familiar with the Tanzanian context, so you might need to provide some of the some definitions there. I've forgotten what I was specifically some of the terms that you're referring to that have a specific Tanzanian context, but I will check. In terms of I think this paper, when you look at it, you are looking at an evolving area, of AI tech and even the regulatory environments that may change. Probably that's a limitation that needs to be acknowledged as well. That is a continuously evolving environment. Not only this particular paper, but it also applies to the others as well. On the recommendations, yes, it's great. You ended on a note of way forward looking. Speaking about the recommendations, but I wonder whether in those recommendations you do specify which, in terms of institutional reforms, you do specify which institutions should lead the reforms, or some of the potential challenges, for instance, that come about when you are looking at the issue of reforms or contemplating reform, for instance, political will, for instance, capacity issues. Yes, I think in terms of the theories I mentioned, in terms of conceptual and theoretical frameworks, there are theories that are mentioned. I could have forgotten, but I'm still wondering whether the practical application was clear in terms of the practical application of the theories to the legal and technical nuances of AI and interoperability. whether they were well explored, but I had a question around the application of the theories, because in some cases you'd find somebody mentions a theory that they are relying on, and then when you go down the paper and look at the application of the theory, it's underdeveloped. And then in terms of the regulatory gaps and the impact on consumers and service providers in Tanzania, yes, your paper, it does make reference to some risks, risks to consumers and financial integrity. I wonder whether there is evidence and some case studies demonstrating some of these effects that I said to that you are mentioning. I think also I had a question around the dual regulatory framework between the Bank of Tanzania and Tanzania Communications Regulatory Authority, specifically, create enforcement gaps, how the dual framework between the bank and the regulatory authority creates some regulatory or enforcement conflicts, and whether you can provide some examples and maybe provide a more detailed explanation and evidence of institutional fragmentation. And probably in this case, you might consider discussing some kind of harmonization in terms of the regulation. And yes, the paper is indeed on Tanzania, but are there lessons that Tanzania can realistically draw from comparative jurisdictions? And is there anything that you see elsewhere that Tanzania can adopt? And we know that, of course, there's a unique socio-economic and technological, political context altogether in Tanzania. But are there any other foreign legal models that are relevant that Tanzania can draw inspiration from? So far that's all, but if there's anything else, I'll definitely just put together a small guidance note. Over to you, Michael.
Thank you. Thank you very much, Ingwe, for that. I now want to, I don't know if Doctor wants to respond now, or those are just fair comments which can help to improve the chapter later. And then if Doc, if you want to in a minute clarify something, you can, but probably in a minute. And then
yeah. Okay, thank you so much, Aboneka. Actually, what have been raised by Dube, they're just fair comments, and actually I'll incorporate all these comments for the sake of improving the paper. So I don't think if there is any sort of reaction from what has been raised. Thank you so much.
All right, thank you very much, Dr. Abdallah, for that interesting discussion and the paper on the payment systems and AI. I am very much interested, coming from East Africa myself. Thank you very much. And now we're going to the last part, which is the way forward and closing. And before I hand over to Hilingwe, I just want to thank everyone, and especially colleagues at the Center for Human Rights and the data protection authorities that are here. We thank you very much, especially Uganda. They have been on since yesterday, and then other colleagues. So I see the network of public interest lawyers in Uganda also. They have been on since yesterday. So thank you. Over to you, Helingwe, to give us the next steps and close us off. Thank you.
Thank you so much, Michael, for taking care of us since morning. And thank you, colleagues, also for taking your time to be with us, to attend, responding to our call, our invitation. And much appreciation as well to all our presenters, our authors, putting together the abstracts, putting together the draft chapters and having them being subjected to a platform such as this one. We really appreciate it. Like yesterday, we mentioned when we started that what we are trying to do here is to contribute to African scholarship, which is still emerging in this area of data protection on the continent. And there are a lot of emerging issues. And we also indicated that this is a second edition of another initiative, which resulted in a book publication that we also shared a link of that publication. You can also just look at it. It's available for free online. It's called Data Privacy Laws, Emerging Perspectives, which was edited by myself and Dr. Lukman Abdurauf from University of Ilorin. So thank you so much. Once again, everyone, I know it's when you're looking at virtual attendance, it's very difficult. Sometimes the concentration threshold can be very low. But thank you so much for being here. In terms of the way forward, I think yesterday as well, when we started, we deliberately brought in Dr. Lukman to try and give us a picture of how the process plays out. So what we have just done right now is to have an initial a discussion around the papers and just to try and offer some insights into how the papers can be improved before the process of peer review, which is the next process. So what's going to happen is that the drafters or our authors are going to receive some communication related to some of the points that have been raised here regarding their chapters, but we are also going to share the recording as well if you want to just go back to the presentation and listen to some of the issues that were raised. We're going to share the recording, and I think we're going to also put it on YouTube as well so that it's just publicly available, because I think these are some of the issues that can benefit other people as well. So after having worked on the paper and submit it, so the review process is going to start early next year. So between now and we don't count December, no one works in no one works in December and early January. So we'll give you a specific date. As Michael is going to communicate with you early February or sometime in February to submit a revised chapter, which is then going to be shared with a reviewer. So we also identify experts around the continent who work on this particular area that you have written on, to also to review your paper, and then the paper comes back to us also for our review, to ensure that the review that has been done by the external reviewer aligns with the objectives that we have in terms of the publication. And then the after we have reviewed, we send it back to the author to incorporate any suggestions or any comments that will have been that arise from the review process. Once we are satisfied that the paper is ready for the next stage, then the manuscript of containing all the papers is then sent to the publisher, Pretoria University Law Press, and also in that the publication process also involves what term do they use? A steward being appointed to preside over, that the publication of the book. So it's another layer of review, just to ensure for quality control as well, so that at the end of the day, it has passed through these stages and this quality control. And at the end of the day, it's a publication that we can all be proud of and available online and all that. So in a nutshell, that's it, but it's not as short as I say. From the previous experience, sometimes you send a paper to the author to incorporate, and then you check whether they've incorporated the comments, and you find that probably they incorporated some and there's still some gaps and it has to go back. So other papers take longer, others the process is a bit shorter, because probably they've incorporated everything. They've done the thorough work in terms of working on their papers. So as I see it right now, there are some papers that won't probably require a lot of revision, but there are some that will require a lot of revision, and that impacts the period that the whole process can take. So otherwise, thank you so much once again, colleagues, for always supporting us, for contributing to African scholarship, for discussing the issues. And we definitely are going to meet in certain spaces, but those that we have, probably this is our first time meeting. It's been a pleasure meeting you. I hope this is not the last time we were engaging on these issues. Let's continue engaging in the different platforms that we find ourselves in. That's it, Michael.
All right, thank you very much, Lingwe, for that closure. And colleagues, thank you very much. From us, we want to thank you for your time and your inputs and insights, and we're looking forward to the product that will come out of this. And to everyone, have a great evening, and definitely contact us if you have anything in regards to digital rights issues and any collaborations. You can write to any of us, and you can check also the center's website. You can always see a lot of things that are happening there. Thank you very much from us all. And I want to thank the authors, I want to thank the contributors and everyone for making time for these 2 days conversation. And I hope that we become better ambassadors of data protection. So thank you, and all of you. Good morning, good evening, and good afternoon, and enjoy yourselves the rest of the week. Thank you very much.